Good morning, everybody. Welcome to the Courtroom Files Live. It's Friday. Happy Friday to all of you. We're going to start out with a new judge to the channel. This is Tony Flores in Lansing, Michigan.
Nomination today and a contempt hearing. Mrs. L, how we proceed?
Your Honor, I believe that case with the contempt hearing today is the possession case. Is that correct?
Yes, that is there's a bond violation on that. Judge, I don't know if it's on the schedule. So
if I may, my understanding is this: there's 25-00666 is the possession of methamphetamine case.
Correct.
The other file 25-01005 FY is an assaultive case. The assaultive case, the people are unable to proceed on today, so I believe that one is going to be dismissed. 25-666 FY, Mr. Shabazz will be entering a plea on. However, as I understand it, at least the contempt on 666 FY is purely the fact that he was charged with the new case. Because that case is going away, I would also presume then that the contempt hearing would go with it.
All right, and Mrs. L.
Your Honor, that's my understanding as well. Since that contempt is the underlying assault, or the underlying factual basis for that is the assaultive case that the necessary witness did fail to appear for after being subpoenaed. I would also be under the understanding that if the assaultive case is dismissed today, the contempt would be as well.
All right, and so let's proceed on. We'll proceed on both files, but let's do the so what are we doing on the 25-00666, the possession of methamphetamine?
That's going to be a plea to a misdemeanor use,
Okay.
Your Honor, the 1-year misdemeanor use. There's no sentencing agreement. I do have an advice of rights form completed by my client, if I may approach.
You may. So let's do that one, and we'll dismiss the contempt hearing, and then we'll go ahead and we'll address 25-01005, which is the assaultive crime that's responsible for the contempt hearing. Okay. All right. So I'm in possession of the advice of rights concerning this matter. Concerning file 25-00666. And Mrs. L, you can place the offer on the record concerning the plea offer, the misdemeanor plea offer.
Thank you, Your Honor. At this time, the people are offering a plea to an added count 2 of use of a controlled substance under MCL 333740423, which is a 1-year misdemeanor and or $1,000 fine. Upon successful plea and sentencing, we would be dismissing count 1, possession.
That would be a plea to the use of methamphetamine. Is that correct?
Correct, Your Honor.
And are there any other plea agreements concerning that matter?
There are not, Your Honor.
Is that a fair statement, Mr. Palmer? It is a plea to count the added count 2 of use of cocaine, which is a 1-year misdemeanor and $1,000, which you provided the advice of rights on, and then count 1 is to be dismissed upon successful plea and sentence.
That's an accurate statement, Your Honor.
All right. So, Mr. Palmer, may I inquire of Mr. Shabazz of his misdemeanor advice of rights?
Of course, Judge.
All right. Thank you. Mr. Shabazz, you understand, you've signed the advice of rights in this matter. These are 12 rights that you went over with your attorney, Mr. Palmer, and you signed the bottom of that. Is that correct?
Yes, sir.
Okay. So I'm going to go through the main rights with you concerning this matter. You have 3 main rights, and that's the right to be tried by a jury, to be presumed innocent, and to testify at trial. If you choose to testify, you may remain silent and it cannot be used against you. Do you understand that, sir?
Yes, sir.
If your plea is accepted, then you'll be pleading guilty to the misdemeanor of 1 year and or $1,000 of use of methamphetamine and a dismissal of the felony count. That's the agreement. If your plea is accepted, you'll give the claim the plea was a result of any promises other than what we've stated on the record, or threats that it was not your choice to plead guilty. Do you understand that, sir?
Yes, sir.
You'd be giving up the right to appeal anything from trial since you won't be having a trial. You'll be pleading guilty to the use of methamphetamine which is the 1 year misdemeanor. Do you understand that, sir?
Yes, Your Honor.
I'm gonna have you raise your right hand. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty of perjury?
Yes, sir.
Okay, thank you. All right, so I'm gonna bring your attention back, sir, to March 1st of 2025 at the offense location of 2025, 1,000 blocks of it's the 1,000 block of Home Street in the city of Lansing. Were you present on March 1st, 2025 on Home Street in the city of Lansing, Ingham County? Okay, and at that time, did you use the controlled substance of methamphetamine?
Yes, I did, Your Honor.
And you knew it was methamphetamine when you were using it? Is that a yes, sir?
Yes, sir.
Okay. And you didn't accidentally use it, you used it to use methamphetamine?
Yes, sir.
All right. Anything towards a factual basis, Mrs. L?
No, Your Honor.
Mr. Palmer?
No, Your Honor, thank you.
All right. I find the factual basis to be knowing, voluntarily, and accurately made in regards to the factual basis for use of methamphetamine. And we'll cover some of the other things. I would think, I don't know if he's in on this, Mr. Palmer, but we're going to refer to probation.
Yeah,
Yes,
and,
yes,
yeah,
yes.
he is in on this, Judge. He's in on this and the other case that I anticipate is about to be dismissed.
Right,
I was gonna argue a bond. Once we get there, I'm gonna request to argue a
Right.
bond.
all right. So I don't know if you'll be out or in, but probation's on the 5th floor. And so if you're out, you have 48 hours to get to probation so they can meet with you. You can set them an appointment and they can do a report for me, all right?
Yes, sir.
And that's the 5th floor of this building. It's all the way to your right, all right? And we'll set a sentencing date for
June 27th at night.
June 27th at 9 o'clock. All right, and then Mr. If I expect what's going to happen on the assaultive crime, Mr. Palmer, did you want to be heard on bond on this case?
Yes, Your Honor, and obviously this is with the presumption, I guess, that the other file, the assaultive case, is about to be dismissed. I would ask that the court consider a personal recognizance bond for Mr. Shabazz. Mr. Shabazz did have a couple of things that were holding him in custody. That being these two cases primarily that are before the court today. Obviously, as the court's aware, we've gone from 2 felony files pending down to now what I anticipate will be 1 misdemeanor that he's entered a plea to, and a presumption at least of probation. The only other thing that's pending at this point for Mr. Shabazz, as I understand it, that's holding him in custody is there is a retail fraud 3rd-degree misdemeanor. That I think the bond on that is $100. It's not before the court today, so I'm not asking the court to address it, but he hasn't posted it because of these other matters. Mr. Shabazz certainly seems to have getting things turned around. I recognize that there's been some delay in that, but Mr. Shabazz and I have had a number of conversations about this. I do think he's got things turned around. He's got a stable address to live at. I anticipate he's going to be working on employment and those kinds of things before he returns to the court in late June. I do think Mr. Shabazz will be a good candidate for probation. He really does have a lack of criminal history or lack of significant criminal history. I would ask that the court consider a personal recognizance bond, given that Mr. Shabazz's matters are now essentially largely cleaned up.
All right, and so I understand the nature. This was initially set at bond at 2,010%, and then it appears it was raised to 3,500 10%, probably on the additional charge.
That's my understanding as well, Judge. And also then because of the bond violation, et cetera, it was raised. He's also got and that other assaultive crime had I think a $7,500 cash or surety bond. So those 2 matters were holding him. I think that now he would be eligible to be out released. He does have a couple of more court dates with the court. He's represented on a misdemeanor by James Harries of my office. Mr. Shabazz is aware of his obligations with regards to that. I don't anticipate having any problems with Mr. Shabazz returning to court. or getting in touch with him. We have good contact information for him. I certainly think Mr. Shabazz understands his obligations and will return as necessary.
All right, thank you. Mrs. L, response to the reduction of bond motion, and I think you understand how the bond was previously set.
Correct, Your Honor. I do understand how the bond was previously set, and I would ask that if the court is inclined to change bond today, that it be reinstated to the original bond in this case. However, we would leave it to the discretion of the court. Thank you.
All right, thank you. I do have a failed to appear as of March 13th. I don't know if that had anything to do with the assault of crime. It was originally set at 2,010% by Judge Simmons, but that was on the felony, and this is a misdemeanor. So now that he's pled to a misdemeanor, so I'm going to reset bond. I'm going to modify bond. Because of the failed to appear, I will set a bond, but it'll be a low 10%. It'll be 1,010%. All right, so it's 1,010% for the modification of bond. If you're out, seek the 5th floor for probation, and we'll see you here on June 27th at 9 o'clock. If not, probation will be to see you, depending on the other file where you're incarcerated. But if you are out, you have 48 hours to go in with probation. All right, sir?
Yes, sir.
All right, and then the bond violation on that contempt, which was due to the assault, is that dismissed at this time, or that's a request by the prosecutor's office on that contempt hearing?
That would be our request, Your Honor.
And I'm assuming you have no objection to that.
No objection, Judge. Thank you.
So bond dismissed. And then we're on the record in docket 25-01005. We've already had appearances for the record. Mrs. L, how are we proceeding on that case?
Your Honor, at this time, the necessary witnesses have failed to appear and the people are unable to proceed today. I do expect a motion from the defense on that today.
All right, Mr. Palmer.
Thank you, Your Honor. At this time, the defense moves to dismiss for lack of probable cause by the prosecution.
And the complaining victim was subpoenaed and you haven't heard from her, Mrs. L.
I have not heard from her and we have attempted to contact her multiple times to no success.
Right, I will be in possession of a nollie pros at the request of defense counsel on docket 25-01005 concerning the 2-count assaultive crime, felony crime. This case will be dismissed without prejudice, which means that the people could reissue if they choose to, but realistically today, Mr. Shabazz, the case is dismissed. All right, sir?
Thank you.
All right. All right, I've signed at the request of the council, the motion dismissed without prejudice. Anything else for the record in docket 25-01005, Mrs. L?
Not for the people.
Mr. Palmer?
No, Your Honor. Thank you.
All right, Mr. Shabazz, you're all set. Thank you for your appearance today.
Okay, once again, good morning, everybody. Welcome to the Courtroom Files Live. So that was Judge Tony Flores. He sits on the 54A District Court in Lansing. It's the first time we've featured him on this channel. Let me know in the chat what you thought of him and if that's a judge that we should consider adding to the more regular rotation. I've got my eyes on 9 different courtrooms already. There's a lot going on, arraignments, landlord, tenant, all of that. Let's pay a visit to Judge Middleton. We haven't seen him in a couple of weeks, and he's actually been on vacation for most of that. So let's spend a few minutes with him.
I already have a attorney right now with legal aid.
All right, we'll discuss that. And
Okay.
Joshua, you're the manager at this complex?
Yes, sir, I am.
I met you that day that little dog bit me in the foot.
Yes, sir, you did. They're no longer in the park.
I like to know my surroundings, Mr. Cramazon, and I walked over in the park one sunny September afternoon during lunch just to see how things were going, and they've got things situated pretty well, and one of the tenants, little dogs, she opened the door and the dogs ran out and bit me in the foot, and she was right there when it happened, but I survived it. All right, also, we've got Kyle Evans.
He's my boss.
All right. And you told me that day that the lady was gonna be moving out,
Yes, sir.
and apparently that happened. All right, well, this is a termination of tenancy. And I don't know whether this is a subsidized lease. The notice to quit was February 25th. The defendant did not move. It looks to me like the lease is up. Ms. Furlow, you have been in contact with legal aid?
Yeah, I talked to Libby. She said she wasn't going to be able to come to the hearing today, but she'll get right back in contact with me. I did my intake and everything, and I do want to take it to trial because I have all the accuracy that I need. I want to take it to trial.
Well, let's
Okay, if that's a termination of tenancy, it's going to take a little bit, and I normally don't leave things in the middle, but Judge Fleischer, again, starting timely. His Fridays are usually very busy. As you can see, he's got a fairly full gallery there, and he's definitely got an interesting jacket on today. So let's follow him with his arraignments for a little bit.
Brown, and Graves.
Right.
Who is Ricky Brown? You are Graves? You are Graves. And you are Thomas. Switch places for me so I don't. Okay. Gentlemen, all of you are charged with racing on the highway. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you.
Thank you, Judge.
Please.
The nature of this case is a racing on a highway case, so I just want to let you know that these dim summaries will be separate for each defendant because they were stopped at different locations, if that makes sense. Okay. On April 17th, 2025, in Harris County, Texas, an officer was on routine patrol when he observed a Silverado pickup truck and a Cadillac motor vehicle accelerate at a high rate of speed side by side in an attempt to outdistance one another. The officer observed a third vehicle, a Dodge Charger, increasing speed while following the other two motor vehicles. The officer accelerated approximately to 108 miles per hour in an attempt to catch up with the three vehicles. The officer noted the posted speed limit on the roadway was 65 miles per hour. The officer notes that he was traveling at 101 miles per hour, maintaining view of the vehicles and recording the incident with his dash camera. The Cadillac and the Silverado truck exited the freeway, and the officer got right behind the pickup truck and paced it, traveling 85 miles per hour. A traffic stop was conducted on the Silverado, and the defendant admitted to the officer he was racing with the other individuals. While speaking with the defendant...
We're talking about Brown, right?
Yes, Your Honor. Okay. And while speaking with the defendant, the other two vehicles arrived on scene and admitted to the officer that they were racing along with the defendant. I guess that covers that.
Who came and admitted?
It says the other two defendants.
The other two came in.
Yes, Your Honor, that's what it states. I'd be happy to read the other.
I'm going to find that there's sufficient probable cause to go forward with your cases, gentlemen. Let me tell you now that the state of Texas and the wisdom of our legislature has made it extremely easy for district attorneys across the state of Texas to seize and take cars from those who are arrested for racing. I have had cases in here where they have seized and taken a car from someone who was caught multiple times participating in this type of behavior. Don't do it. Do you understand?
Yes, sir.
If I find that you do, the first thing I will do is I will put you in jail, and then I'm going to take your ability to drive away from you while this case is open. Living in a city as big as Houston without the ability to drive blows. Do you understand?
Yes, sir.
Each of you, none of you participate racing, street takeovers, donuts, reckless driving maniacally, or putting others' lives in danger. Do you understand? If I find that you're driving at 100 or something like that, it's just not going to go well for you guys. So do you mind filing conditions on each of, no racing, reckless driving, takeovers, anything of this nature, please?
Yes, Your Honor.
And then also, let's go through each one to see if they have valid licenses.
Yes, Your Honor. For defendant, Thomas, we do have an eligible license.
Okay. Also, each of you you're not allowed to drive unless you have a valid Texas driver license and liability insurance in your name. You must have car insurance. If you don't have either, you are not allowed to drive.
For defendant Brown, we do have an eligible license as well.
Okay.
And then for defendant Graves, the license is eligible.
All right. Gentlemen, do you have the ability to hire a lawyer, Mr. Brown? Okay. Do you have the ability to hire a lawyer? Okay, we're going to give you time to go hire a lawyer. We're going to give you 30 days. When you come back, please have a lawyer. I'm going to have you each go to Victoria, sign a reset. Then we will have you take a seat in the jury box while we get your bond conditions. We'll have you sign it, and then you'll be free to go. We have enough death on our streets. Don't contribute to it. You understand?
Sure.
All right, come on, guys.
Well. All right, Judge, next is page 4, Castillo.
Real quick, while he's waiting for that person to come up, we're not going to go to this court, but just to show you, if you look on your screen, that's Judge Washington's docket right now. It's stacked. There's a lot going on out there today.
Go ahead and sign. Got it. Thank you.
All right, you were Jose Castillo.
Yes, sir.
Oh. Mr. Castillo, you're charged with failure to stop, give information. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Thank you. The defendant was driving westbound on 9100 Willow Meadow at approximately 7 p.m. and crashed into a parked white Chevy Silverado. The defendant's right side mirror struck the left side mirror of the parked pickup truck. The complaining witness identified the defendant's vehicle with surveillance video and rode around the neighborhood until he located the vehicle. The complaining witness gave the address to the officers who went to the location. They met with the defendant, who stated he was aware he hit the truck, but was going to go back later.
Okay. Mr. Castillo, I'm going to find that there's sufficient probable cause to go forward with the case. You run his license, please.
Yes, sir.
You are not allowed to drive unless you have a valid Texas driver license and liability insurance. If I find that something like this happens again, or if you pick up a new case or become a danger, I will revoke your bond and put you in jail. Do you understand, sir?
Yes, sir. It's eligible, Your Honor.
Okay. Mr. Castillo, do you have the ability to hire a lawyer? Okay, we're going to give you time. I'm going to have you go to Victoria, sign a reset. We will have you take a seat in the jury box while I get your bond conditions. Once you sign it, then you'll be free to go. Please.
All right, Judge, next page 5, Contreras, come on up.
Good morning, Mr. Contreras. Sir, you are charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Thank you, Your Honor. The defendant and the complaining witness were in an Uber on April 17th, 2025, when a fight broke out. The defendant jumped on top of the complaining witness. The complaining witness and the defendant were dropped off by the Uber driver at the complaining witness's house. Once at the property, the complaining witness attempted to go inside. The defendant started a physical altercation where he struck the complaining witness with closed fists, causing pain and injury to the complaining witness. The complaining witness was able to get away from the defendant and lock the door with the defendant outside. The complaining witness has visible injury and bleeding of the face observed by officers who arrived on the scene.
And is there alcohol or dope involved? Just pled to an assault a month and a half ago, and here we are again.
Your Honor, the nature of the relationship, it states as a roommate of 2 weeks, and they were at a club known as Wagos on Washington Street. And Your Honor, according to the dim summary, the complainant stated the defendant got too drunk.
Mr. Contreras, we are now going to handle whatever issues that are arising with you. If I find that you're another danger to the community, I will put you in jail. You're ordered not to consume alcohol or illegal drugs, and I'm going to put an ankle monitor on you so I know that you're not consuming. You are not allowed to go to bars, nightclubs, anything of this nature where alcohol is primarily sold. Do you understand? So I'd like to put a scram on him. Okay, yeah. Waive the fee. You're not to have contact with the complaining witness in this case. If I find that you do, I will put you in jail. No more PR bonds. Do you understand?
Yes, sir.
Do you have the ability to hire a lawyer? What do you do with yourself these days?
The dad has taken away everything from us. So we're trying to figure that out. And that's why I moved in with Chris.
It's time for you to get a job. And I'm making that a condition of your bond. You're not doing anything and you have way too much time on your hands. So you're becoming self-destructive. This is now your second assault case within the last month and a half. No more. Do you understand?
Sir.
Can you reach out to the MAC for him, please? And then you're not to be in possession of weapons as well. I'm going to have you go to Victoria, sign a reset, and then we will have you take your seat in the jury box. You're going to have to get with them for your bond conditions. Then we'll get you a lawyer soon. Okay. Okay.
Why does he do that? It makes me sad. Let's go to Judge Washington because she has so much going on.
Any of them, because it has to be taken out of the lien system.
اوكي حاول ما تنتهكن على الآلية ل 24 ساعة لأنه طلعناهم من السيستم تبعهم.
Do you understand, sir?
Yeah.
No.
Yeah. Yes.
All right. We're all set. This case is over.
اوكي خلصنا القضية الآن.
Thank you, Mr. Miller. Have a good day.
Okay. Thank you for anything else I can help you with?
No, that's it.
Thank you for using our services. Enjoy your day. Bye-bye.
Bye-bye. Ypsilanti Township versus Kaylani Stanley, 25T00079.
Paul Barnett on behalf of the township.
Allison Muller here on behalf of Kaylani Stanley. Ms. Stanley, can you please state your name?
Kaylani Stanley, please unmute your device, turn on your screen and state your name.
I'm not sure if I see her on.
She is not present. Mr. Barnett, what is your request?
Candidly, our victim is not here either, so we would not have been able to proceed, but Mr. Stanley's not here either, so I suppose I'll leave it in your discretion. I would not object, I guess, to a show cause.
Your Honor, I would either ask for a show cause or if the court would be willing to pass the matter, and I'll see if I can get a hold of Miss Stanley.
Willing.
Okay.
I need a show cause date on a Wednesday. Show cause will be May 21st, 2025. At 9 a.m. Bond is continued. There is also a violation of bond. Apparently, what kind of case is this? Is there an allegation of alcohol use or drugs in this case?
One moment, Your Honor. It doesn't appear that to be that.
Okay, thank you. I will not act on that at this time. Court will call the case of the State of Michigan versus Christopher Jean Gillis, case number.
Okay, Judge Leopard Print is back, so we'll continue with his docket.
Yes.
Okay,
Judge,
Rick, ready?
next, page 5, Brady Show, come on up.
Good morning, Mr. Crenshaw. Sir, you're charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Thank you. On April 19th, 2025, in Harris County, Texas, officers were dispatched to a disturbance call. An officer met with the complaining witness who stated that the defendant has been staying with him off and on. The complaining witness advised that he came home and found garbage in the apartment, which the defendant denied having done. The complaining witness stated the defendant started recording him, accusing him of threatening the defendant. The defendant then put the phone in the complaining witness's face, and the complaining witness took the phone, at which point the defendant punched the complaining witness several times in the face, causing pain. The defendant then attempted to take an electric scooter, which eventually struck the complaining witness in the leg, causing pain. The officer observed the complaining witness to have multiple injuries on his face.
All right, Mr. Crenshaw, I'm going to find that there's sufficient probable cause to go forward with the case. I'm ordering you as a condition of your bond not to have contact with the complaining witness in this case and not to be in possession of any weapons. You understand? I don't see that a MOA or a protective order has been issued. Do you? You see a tray protective order?
The stipulations of my bond. I know that.
On Crenshaw? Okay. I'm now entering in what's called a matchless order for emergency protection. This is a court order that identifies Mr. Montgomery as a protected individual. You cannot commit family violence or an assault against this person, commit an act in furtherance of an offense under section 42.072 of the Texas Penal Code, which is a stalking statute. You cannot threaten, harass, use another person to communicate a threat or harassing behavior. You cannot be in possession of a weapon or within 200 feet of where he lives or where he works. Do you understand? If you violate this court order, the state can and probably will file a violation of a protective order. It's one of the worst cases you can pick up. Do you understand? Do you have the ability to hire a lawyer, Mr. Crenshaw? Do you work?
Yes, sir. I'm currently looking for a job.
It's time.
Yes, sir.
We're going to make sure that that happens. So 2 weeks, I'm going to bring you back and I want to see what you have done to get a job. If you've done nothing, it's not going to go well for you.
Yes, sir.
You understand? All right. I'm going to appoint you a lawyer. I'm going to have you go to Victoria Center Reset. We will have you take a seat in the jury box. I'm going to get your bond conditions. Do not leave until you sign them.
Yes, sir.
You're not to have contact. You're not to be in possession of weapons. You understand?
Yes, sir.
Come on.
Like a ticket.
Oh, hold on. Come sign for your protective order.
All right, Judge, next is page 6. Easy.
Hey, can you file the no contact of weapons, please, on that?
Yes, sir.
Mr. Crenshaw? Okay. Good morning, Ms. Woodward. Good morning, sir. So you're charged with driving while intoxicated. You're facing up to 6 months in jail and a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you, sir.
Okay, Your Honor.
On April 17th, 2025, in Harris County, Texas, the law enforcement officer made contact with the complaining witness who stated that she had a green light and the defendant's vehicle struck her on the driver's side. The complaining witness was transported to the hospital. A wheel witness stated that he saw the defendant driving at approximately 90 miles per hour and run the red light and hit the complaining witness's vehicle. The wheel witness followed the defendant, and the defendant stopped a few hundred yards away from the scene. The wheel witness stated that he believed the defendant was attempting to flee, but only stopped due to mechanical issues with his vehicle. The law enforcement officer came into contact with the defendant and noticed slurred speech, an odor of alcoholic beverage, red, bloodshot eyes, disorientation, and inability to follow instructions. The defendant admitted to driving. Standard field sobriety tests were conducted. A 6 out of 6 was recorded on the HGN, and the defendant refused the walk and turn and one-leg stand. The defendant also refused to provide a specimen. A blood warrant was obtained and a blood draw was executed.
Jesse, I'm going to find that there's sufficient probable cause to go forward with your case. I'm ordering you now as a condition of your bond not to consume alcohol or illegal drugs. I'm going to randomly test you. If I find that you're using, I will revoke your bond and put you in jail. Do you understand? Can you look to see any prior DWIs and if he has a license, please?
No prior DWIs and no license is eligible, Your Honor.
Okay. As long as you have a valid Texas driver license and liability insurance, you may continue to drive. But like I said, don't consume alcohol. Don't use illegal drugs. You will be randomly tested. Because you have a lawyer, I will waive your appearance. You don't have to waste your time coming to court, but you must stay in touch with her and she'll tell you if and when you have to come back. For now, we'll have you go to Victoria Center Reset. You'll get the pre-trial for your bond conditions and then you're free to go.
Thank you,
Honor. Hey, I don't have the bond conditions for the third driver. Thomas. Did you file conditions on Thomas as well?
I did, Your Honor.
You did? Okay. Maybe we just don't have it yet. Vic, what'd you say?
I was about to go ready for the next.
Yeah, go for it.
Okay, next is page 10, Martinez, Georgina.
Bond conditions for the last defendant, there's no alcohol, no drugs.
Don't worry about it. It's a DWI, so it'll be supervised.
Mr. Brown.
So you are Ms. Martinez?
Yes, sir.
Ma'am, you're charged with interference with the duties of a public servant. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present if you cannot afford one. No. I'm sorry, you're charged with DWI.
Yeah.
Okay, sorry, wrong Martinez. You're facing up to 6 months in jail and or a $2,000 fine. You're charged with DWI. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. If you cannot afford a lawyer will be appointed to represent. Okay.
Thank you. On August 5th, 2024, a law enforcement officer was dispatched to a major crash near the 3753 block of Highway 45 in Harris County, Texas. The law enforcement made contact with the witness. The witness stated she felt force pushing her car, causing her to spin out and crash. The law enforcement officer made contact with the defendant. The defendant stated she was operating the motor vehicle when the crash happened. The defendant stated she was driving home from a friend's house. The law enforcement officer observed red, watery, bloodshot eyes, slurred speech, belligerent behavior, aggression, and lack of cooperation. The defendant continued asking for ice packs after having received them and was crying, yelling, and swearing at the law enforcement officer throughout the investigation. Standard field sobriety tests were administered. A 2 out of 6 was recorded on the HGN, a 7 out of 8 on the walk and turn, and the one leg stand was refused. A blood search warrant was obtained and executed, and the blood results came back to a 0.12.
Right to be on.
Let me look at the out of county. Please. Judge, I'm not seeing any prior DWIs here.
Okay. License.
And the license is eligible.
Martinez, I'm going to find that there's sufficient probable cause to go forward with your case. I'm ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm going to randomly test you. If I find that you're using, I will revoke your bond, put you in jail. No more PR bonds. Do you understand, ma'am? Do you have the ability to hire a lawyer?
No.
I can have you fill out an application. I need to know everything about you, how much money you make, how much money you have at the bank, what kind of car you're driving. I'll take a look to see whether you qualify.
Okay.
Deputy Miranda is going to give you an application. I'll have you sign a reset with Victoria. We'll have you take a seat. Eventually, you're going to meet with pretrial services, and then we'll take a look at your application. Please.
Mr. Graves. All right. Next judge is page 11, Martinez, Victor.
Mr. Martinez, you're charged with driving while intoxicated, second offense. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, sir.
Thank you, Your Honor. On April 17th, 2025, in Harris County, Texas, an officer observed a motor vehicle traveling at a high rate of speed. He observed the vehicle brake hard to slow down. The officer then got behind the vehicle and observed it to have an expired registration as of January 2025. A traffic stop was conducted, and the defendant was identified by his Texas ID card. The officer approached the motor vehicle and observed the defendant in the driver's seat and the defendant to have glossy eyes, slurred speech, and an odor of alcoholic beverage. The defendant admitted to the officer that he had 5 to 6 beers prior to driving. The defendant stated he has a leg injury on his right leg. Standard field sobriety tests were conducted. A 4 out of 6 on the HGN, a 4 out of 8 on the walk and turn, a 1 out of 4 on the one leg stand. The defendant stated that despite his leg injury, he does work out and have an active life. The defendant stated he was a 5 out of 10 level of intoxication on a scale from 1 to 10. The DIC was read and the breath test strip was refused. A blood warrant was issued and the blood draw was executed.
Okay. Mr. Martinez, can you run his license, please?
Yes, Your Honor.
I'm going to find that there's sufficient probable cause to go forward with the case. I'm ordering you now, as a condition of your bond, not to consume alcohol, illegal drugs or unprescribed controlled medication, I'm going to randomly test you. So if I find that you're using, I will put you in jail. No more PR bonds. Do you understand?
Yes, sir.
I'm now placing a restriction on your license. You are not allowed to drive any vehicle that doesn't have an ignition interlock on it. If you're caught driving a vehicle that doesn't have one, I will put you in jail.
Yes, sir.
We are sending notice to DPS so that every single officer in the state knows that you're required to have an interlock in your car. So if you're caught wherever and you don't have one, officers will put you in jail.
Yes,
Do
sir.
you understand?
Yes, sir. Your Honor, can I speak?
Don't.
No, good. I got.
Don't. I don't want you to say a thing. Now's not the time. You have the right to remain silent, to exercise that right. Just don't say anything. Don't. Do you have the ability to hire a lawyer, Mr. Martinez?
Not a problem.
Deputy Miranda is going to give you an application. We'll take a look to see whether you qualify. I need to know everything about you, where you work, how much money you're making, how much money you have at the bank, what kind of car you drive, how many cars, stocks, bonds, mutual funds, everything. And then I'll take a look to see whether you qualify.
Judge, we have that the license is not eligible.
You are not allowed to drive. You will be signing an affidavit with me today, Mr. Martinez, and I'm telling you now, I don't give a rat's behind what your excuses. If I find that you drive, I can have a contempt hearing. You can be facing an additional 6 months in jail and a $500 fine every time you drive. This affidavit is what you're going to be signing, promising me you're not going to drive. Nothing in this world can justify you getting to a car and driving. Jesus comes down and needs to ride to church. Do not drive. You understand me?
Yes, sir.
Mr. Castillo?
Because you don't have a license, because you're not going to drive, I'm going to give you a portable device that you're going to take with you everywhere you go to prove to me that you're not consuming.
That's what I was gonna talk to you about. I was talking about my bond conditions.
Mr. Martinez, in the last 1.5 years, you have had 1, 2, 3, 4, 5. You are on your 6th case within the last 1.5 years. There's nothing at this time that you can try to negotiate with me. Do you understand?
I understand. It's about work.
Stop. All I want is my streets to be safe.
Yes, sir.
And if I find that you're in danger, anything 1 iota, it's just not going to go well for you.
I understand.
Okay, do you mind giving an application and we'll have you swear to us?
Are you with Thomas's phone?
Yeah, I can.
Oh, yeah, we never got Thomas's.
Gary and Thomas?
Yeah, I'll meet them.
Raise your hand.
Ready?
Yes, sir.
Mr. Gallegos.
Daniel Martina Pedraza.
And bless him.
Good morning, Your Honor.
Page 9?
Yes, Judge.
Okay.
Morning, Judge.
Hey, how are you?
It's very good.
Happy Friday, man.
Higher.
Did you say Martina?
Martina Pedraza.
You, hey, this is now not the time for you to talk to him about this. You're Martina Pedraza.
Yes.
You're charged with driving while intoxicated. It's elevated to a Class A misdemeanor because of the high blow. You are facing up to a year in jail and/or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Thank you, Your Honor. On April 18th, 2025, in Harris County, Texas, a law enforcement officer observed a vehicle stalled in a moving lane of traffic. The law enforcement officer approached the vehicle and found the defendant in the driver's seat asleep with the vehicle running and foot on the brake pedal. The law enforcement officer woke the defendant up and noticed a mild odor of alcoholic beverage, slurred speech, and glossy eyes. The defendant admitted to consuming alcohol. Standard field sobriety tests were conducted. A 6 out of 6 on the HGN was recorded. A 7 out of 8 on the walk and turn. A 3 out of 4 on the one-leg stand. The defendant consented to breath and blew a .157 and a .154.
Can you look right at the eyes and license?
Yes, Your Honor.
So Martina, to find that there's sufficient probable cause to go forward with the case, I'm ordering you now as a condition of your bond not to consume alcohol, illegal drugs, unprescribed controlled medication. I'm going to randomly test you. If I find that you're using any alcohol or illegal drugs, I will put you in jail. No more PR bonds. I don't know what your immigration status is, but if you're not in this country with permission and you go to jail and immigration finds you because they sweep it hourly, if they find you, they will put a detainer on you and you will be stuck like Chuck in there until this case is over with, and then you get shipped off to immigration. Do you understand?
Yes, sir.
Yes, sir.
If you do not have a Texas driver license and liability insurance, you are not allowed to drive, and that is also a bond condition.
Your Honor, we have no prior DWIs, but the driver's license data is not populating at all. There's no indication.
No license.
No license, Judge.
Do not drive, Mr. Martina. You will be signing an affidavit with me today promising you're not going to drive. I don't care what your excuse is. If I find that you drive, I can have a contempt hearing. You can be facing an additional 6 months in jail and a $500 fine. Nothing in this life can you say that will justify driving. Do you understand?
Yes, sir.
Temptation is big. Just don't do it.
Okay.
So for now, I'm going to have you come up here, swear to us that you're not going to drive. We will get you to Victoria where you will sign a reset. You will eventually get with pre-chopper your bond conditions, and after that, you'll be free to go. Because you have a lawyer, I'm going to waive your appearance. You don't have to waste your time coming to court, but you must stay in touch with counsel, and he will tell you if and when you have to come back to court. If he tells me that he cannot get a hold of you because you're ducking and dodging phone calls, text messages, I'm going to issue a warrant for your arrest. If they call you to go take a drug test and you fail to appear, a warrant for your arrest will be issued.
Yes, sir.
All right, come on.
Hey, Judge.
Thanks.
So, as is typical on a Friday, we'll continue to ride with Judge Fleischer as he moves through his arraignment docket. But real quick, back to Judge Washington's court. Her morning is not getting any easier. She still has a ton of people in line. Lots of contestants for her this morning.
Mendez? Mendez.
Blessing.
Yes, Your Honor.
We need the costume on this.
Yes, Your Honor.
Is 2560811. You are Miss Morales Vega.
Yes.
Ma'am, you're charged with prostitution. You're facing up to 6 months in jail and a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am.
Thank you, Your Honor. On April 19th, 2025, in Harris County, Texas, an officer was working in an undercover capacity in plain clothes when he entered a sexually oriented club and sat down at a table. The officer engaged in conversation with the defendant. The defendant agreed to participate in oral sex with the officer for a fee of $400. The officer notes that the conversation was recorded. The arrest/enforcement team detained the defendant and took her into custody without incident.
And I'm going to find that there's probable cause to go forward. I'm ordering you now as a condition of your bond. Evasion is lifetime behavior. If I find that you do, I will revoke your bond and put you in custody, ma'am. I don't know what your immigration status is, but if you're not in this country with permission and you go to jail and immigration finds you, they will put an immigration detainer on you, and you will be stuck in custody until this case is over with, and then you get shipped off to immigration. Do you understand?
Yes, sir.
Can I provide you a lawyer today? Would you like a lawyer?
¿Usted quiere un abogado? Yo tengo un abogado. I have an attorney. ¿Quién es? ¿Quién es?
Are they supposed to be here today?
Not today. Lo ocupo. ¿Ocupas phone? Sí, pero no digo como que no tenía que presentarse ni ella. She said she hired one, but he's told her that he did not need to be here today.
Person hasn't filed any documents. I don't know. I mean, I can, if you would like, I can give you more time. I'm happy to give you a court-appointed lawyer today if you want one. You tell me what you'd like to do. I can, reset you and give you more time. Normally lawyers file documents.
Give me another date.
Okay. Like I said, if you want a free lawyer, I'm happy to give you one today. So if you have problems when you're out there, you can come back and we're happy to give you one.
I have one.
Okay, that's fine. I just, hopefully they'll come here for the next setting. I don't know. For now, I'm gonna have you go to Victoria, sign a reset. After that, I'm gonna have you take your seat in the jury box while we get your bond conditions. We're gonna have you sign them, and after that, you'll be free to go. Do you mind filing your conditions, please?
Absolutely.
No engaging in this.
Yes, Your Honor.
All right, Judge, next is page 17. Rosalba.
What did you say? What page?
Page 17.
You are Mr. Rosabal Matos.
See. Yes.
Sir, you're charged with driving while intoxicated. It's elevated to a Class A misdemeanor because of the high blow. You are facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Judge, on April 19th, 2025, in Harris County, Texas, an officer observed the defendant run a red light on North Shepherd Drive. The officer then observed the defendant's vehicle fail to drive in the designated lane, striking the raised median and causing his tire to go flat. A traffic stop was conducted. The officer made contact with the defendant and observed the defendant to be the driver and sole occupant and to have bloodshot eyes and slurred speech. The officer could smell an odor of alcoholic beverage emitting from the defendant's vehicle and from his person upon his exit from the vehicle. Officer Castrejon spoke to the defendant due to the defendant being a Spanish-only speaker. The defendant admitted to consuming one beer. Standard field sobriety tests were conducted. The officer noted a 2 out of 6 on the HGN, but also noted that the defendant would not follow the stimulus during distinct and sustained nystagmus at maximum deviation. Therefore, the officer was not able to observe the clues on that basis. The officer noted a 3 out of 8 on the walk and turn and a 3 out of 4 on the one-leg stand. The DIC was read on a recording in Spanish at the Joint Processing Center. The defendant consented to a breath test. The 15-minute waiting period was observed and the breath test came out to a 0.161 and a 0.153.
Any prior DWIs and a license?
No prior DWIs, Judge. I'm checking on the license.
Que si tengo licencia. Find that there's sufficient probable cause. I'm ordering you as a condition of your bond not to consume alcohol or illegal drugs. I'm going to randomly test you. If I find that you're consuming, I will revoke your bond and put you in jail. If you're not in this country with proper permission and you go to jail and immigration finds you, they will put a detainer on you and you will be stuck in custody until this case is over with and they get shipped off to immigration. They sleep it daily, hourly. So behave while you're in this country. You get no more warnings from us. Do you understand? If you do not have a Texas driver license and liability insurance, you're also ordered not to drive.
I do have.
Judge, it appears that it is eligible.
As long as you have a valid license and liability insurance, car insurance, then you will be able to drive. That is also a condition that you maintain liability insurance. Do you have the ability to hire a lawyer? No.
No.
I can have you fill out an application, but I need to know everything about you. I need to know what kind of work you do, how much money you make, how much money you have at the bank, what kind of car you drive, any other sources of income, and I'll take a look to see whether you qualify. For now, Deputy Miranda's going to give an application. I'm going to have you go to Victoria, sign a reset, and then we'll have you take a seat in the jury box while we take a look at everything. Please.
Just real quick on 13, top of 13, was that state flood conditions?
Yes. Yeah.
There's another story. Easy. Next judge is page 23, Vera. 25605 2560573.
I know, don't be calling me on Monday because I'm being margarita.
You are Mr. Vera Quiroz.
Yes, sir.
Sir, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Thank you, Your Honor. On April 17th, 2025, an officer responded to a call for service for a possible failure to stop and give information in Harris County, Texas. The witness stated to the officer that he observed the defendant strike a maroon four-door sedan from behind, drive around the vehicle, and then drive away from the scene without stopping to provide any information. The witness followed the defendant and observed the defendant to increase and decrease his speed frequently, fail to drive in a single lane of traffic, and nearly strike other vehicles until his car became disabled on Highway 249. The witness observed the defendant to exit the vehicle and to be the sole occupant and operator of the vehicle. The officer made contact with the defendant and observed a strong odor of alcoholic beverage, glossy bloodshot eyes, and poor balance. The officer detained the defendant, and while removing a pocket knife from the defendant's pocket, the officer observed a bulge and a plastic feeling in the defendant's pocket. The officer observed a faint odor of marijuana, so he removed the plastic bag, which did in fact contain a usable amount of marijuana. Standard field sobriety tests were conducted. A 6 out of 6 was reported on the HGN, a 5 out of 8 on the walk and turn, a 1 out of 4 on the one leg stand. The DIC audio was played for the defendant, and the defendant agreed to a breath test, which yielded a .148 and a .143. The marijuana weighed approximately 0.2 ounces.
Priors, no license.
¿Tiene antecedentes? ¿Tienes
Mr.
No,
Vera,
no priors, Judge.
okay.
no driver's license?
Mr. Vera, I'm going to find that there's sufficient probable cause to go forward with the case. I'm ordering you now, as a condition of your bond, not to consume alcohol, illegal drugs, unprescribed controlled medication. I'm going to randomly test you. With you, I'm going to test you 50 days from today. If I find that you continue to use marijuana, I will revoke your bond. I'm going to put you in jail. If you're not in this country with proper documentation and you go to jail and immigration finds you, they will put a detainer on you because they sweep it daily. Do you understand?
¿Lo entiende?
Yeah.
Yes.
You are not allowed to drive if you don't have a Texas driver license and liability insurance. That is also a condition of your bond. You do not have a license, you will be signing an affidavit with me today. Mr. Vera, in this short life that we have, do not drive, because if you do, you will pay dearly. Do you understand? This is a promise that you're going to make to me, that you're documenting that you're not going to drive. Nothing you say can justify driving at all. Do you understand?
Is it?
If you get a license and insurance, come talk to me, and then I'm happily will take this off. But until that point, you do. Do you have the ability to hire a lawyer? How old are you, Mr. Barrett?
Yes.
No.
23?
Do you work?
Yes.
Do you have the ability, do you have the funds to hire a lawyer?
No.
If you want, I can give you an application and you can apply for a court-appointed lawyer. I need to know everything about you and I'll see whether you qualify. Above all else, do not use, because it's really not going to go well for you. Do you understand? Okay. Deputy Miranda's going to give you an application. I will have you go to Victoria Sign and Reset. You're eventually going to meet with pretrial services for your bond conditions. After that, we'll take a look at your application. Come on. Hey, Glossa, you're earning, huh? You're doing great.
The bottom of page 8, Judge. I don't know how to say that.
Come on.
Nico? That would be my guess. All right, page 8, Nico?
Eco Soul, come up. Do you need the class number on this block?
Yes, Your Honor, please.
560926.
26?
Yeah, 0926. Mr. Iko Soul, you were charged with tampering with a government record. You are facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Thank you, Your Honor. On April 19th, 2025, in Harris County, Texas, a law enforcement officer ran a temporary tag on the defendant's vehicle that did not come back to anything, and the officer initiated a traffic stop. The defendant stated he did not have the title to the vehicle, and a second check on the temporary tag did not come back to anything.
Did he say that? Read it to me again. I zoned out. Please.
The law enforcement officer ran a temporary tag on the defendant's vehicle that did not come back to anything, so he initiated a traffic stop.
Okay.
The defendant stated he did not have the title to the vehicle, and a second check on the temporary tag did not come back to anything.
Did he ask him if he put the tag on there? Did he ask him? I mean, let me see how it's charged. Did then and there unlawfully, intentionally, and knowingly present the thing attached hereto as Exhibit A with knowledge of its falsity and with the intent that it be taken as a genuine governmental record. That's a specific intent crime, you know, somehow you have to show me that he knew of its falsity.
Look at it.
Judge, I'll just read straight from the DIMS. I met with the defendant, informed him of the reason for the stop. I then asked for a Texas driver's license that provided me with a Guatemalan ID. I then asked the defendant when he bought the vehicle. He advised me that he bought the vehicle 3 months ago. When I asked the defendant if he has the title to the vehicle, he then advised me that the guy who sold the vehicle still has the title. The defendant stated that he bought the vehicle 3 months ago again. When asked for the title, he stated that the guy who sold it still has the title again.
I'm going to find that there's no probable cause to go forward with your case, Mr. Echo. If you do not have a Texas driver license, you are not allowed to drive. At some point, if you continue to do things that may break the law, you go to jail and immigration finds you, they will put an immigration detainer on you and you will be stuck like Chuck. If, I don't know what your immigration status is, but if you're not in this country with permission, you must live like you have a halo above your head. If not, there are serious consequences. Do you understand? Please take a seat. Thanks, Boston.
Next judge is page 14, Mutes.
You are Arthur Mukes. Mr. Mukes, you're charged with resisting arrest, facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir. Please.
Thank you, Your Honor. A law enforcement officer was dispatched to a disturbance call on April 19th, 2025 in Harris County, Texas. The officer observed the defendant to be outside of the residence with what appeared to be an injured hand. The defendant stated he injured his hand while punching a wall when he was in an argument with his wife. The defendant stated that he had been drinking Crown and requested medical attention to the scene. The officer attempted to make contact with the female at the residence who refused to open the door. She only stated that the defendant should not be there at the residence and that she was in fear of the defendant. The defendant advised that he would leave the location and return at a later time. Later on that day, the defendant contacted Precinct 7 dispatch and stated that he was going to kick the door down at the aforementioned residence. The officers returned to the location and made contact with the defendant, who stated that he was going to kick the door down as soon as the officers left the location. Due to the defendant's apparent intoxication and the danger he posed to himself and others, the officers attempted to place the defendant in custody for public intoxication. The defendant became actively resistant and pulled away from officers while being escorted to the vehicle. The defendant told the officer, quote, "I'm coming for you," multiple times as he refused transport. The assistance of 4 officers was required to place the defendant in a patrol vehicle. The officer notes that the defendant actively resisted for 7 minutes and 13 seconds.
Mr. Mukes, I'm gonna find that there's probable cause to go forward. Now's not the time. I know you're itching to say something, but look, I've got a bunch of prosecutors here. I don't want you to say something that hurts your case. Stop. Resist all attempts. If you want, I can give you a lawyer today and you can give your side to the lawyer. Okay, but right now, don't. You're only hurting yourself more when you think you're helping. Don't. I'm trying to help you here, Mr. Mukes. The only condition I'm placing on you now, you're not allowed to consume alcohol. Do you understand? If I find that you're using alcohol or illegal drugs, I will put you in jail. Just don't use. Okay? Do we know if she wants to have contact with him?
Judge, the offense date was on the 19th. We have not been able to reach out with the complaining witness yet.
So let's do this. I'm gonna have them reach out. I want to know if she wants to have contact with you. If she's okay with it, then I'm gonna allow it. Okay? Just don't. So we're gonna try to do work on our side or their side to see if they can reach out to her and see if she's okay with contact with you. So let me see.
Morales Vega?
Okay, so hey, do you mind reaching out to the MAC for Mr. Mukes? I'm gonna get you a lawyer here for you soon. I'm gonna have you sign a reset with Victoria. We're gonna have you take a seat in the jury box. Just look. Just don't. All I'm asking you to do, man. Okay?
I was the victim here and hell.
I know there are two sides. Mr. Mukes,
I'm the one who called them for help and they locked me up and violated my rights.
hey, Mr. Mukes, there will be video. We will take a look and we'll see because the evidence is going to point to whose side's correct. I don't know. I wasn't there. Stop. Don't. Please.
Couple things real quick. Link, I agree with you on resisting arrest. My view on it has always been it needs to be coupled with something else. Like you're charged with theft and in the process of being arrested you resisted, so it's another charge. I don't like it when they just charge resisting and nothing else with it. It needs a companion in my opinion. And Mike, you're talking about marijuana down in Australia. We kind of have a similar thing here. First off, here in the United States, it's still technically illegal everywhere because it's illegal on a federal level. And if you go by the Constitution, federal law trumps state law. So it is in essence illegal everywhere. But on top of that, in the states where it has been quote unquote legalized, there's not good standards for how to measure it. And understanding of what it does to the body and everything else. So it's a mess from a DUI standpoint here too.
Thank you, Your Honor. On April 17th, 2025, in Harris County, Texas, an officer observed a pickup truck change lanes without using a turn signal. The officer observed the vehicle change lanes twice prior to initiating the traffic stop. The officer approached and observed the defendant to be the driver and sole occupant of the vehicle. The officer noted a strong odor of alcoholic beverage emitting from the defendant. The defendant was ID'd by his Texas driver's license. The defendant stated that he did not know how to provide proof of financial responsibility. As the defendant responded to the officer's questions, the officer noted an odor of alcoholic beverage emitting from the defendant's breath. Standard field sobriety tests were conducted. A 6 out of 6 was reported on the HGN, and the defendant stated that he could not perform the walk and turn or the one-legged stand. The DIC was read, and the defendant refused to provide breath or blood voluntarily. A blood warrant was obtained, and the defendant's blood was drawn.
Yeah, may I respond?
Please.
Okay, first of all, Judge, the reason, it's not on there for some reason, but the reason he told the officer he can't do it because he had surgery to his back and to his knee. He can't do it. Secondly, there's no mention of any slurred speech, no bloodshot eyes, no swaying.
I mean, yet I was actually thinking about that as well. All you have is an odor of alcohol.
And then that-
Anything, there's no accident. It's just a turn. All we have is an odor of alcohol. Is there anything else? The odor alone is insufficient.
No, that he was coming from a tattoo shop and the police officer asked him, is he alcohol because of the tattoo?
Is he what?
He just had a tattoo put on. That's he was coming, so that's the odor of alcohol.
Come on, man.
That's what, no, that's, I'm just saying. I mean, that the officer actually asked him that question.
What are they, the little alcohol that you put on your skin, you tell me that?
I don't know how it works, Judge, but I've never had a tattoo.
Killing me. You're killing me, Smalls.
Your Honor, the law enforcement officer does state in the DIMS that there is a distinct odor of an alcoholic beverage emanating from the defendant's breath as he spoke.
Yeah.
That's
That it?
all we have before we initiated the standardized post-firing test.
Okay, that's not enough. All right, I'm gonna find no probable cause in your case, Mr. Mears. You know,
So
we have enough death on our streets now, you know? $40. One button will get you a car wherever you want to go in this life. You know what I mean?
Yes, sir.
Use it. All right, please.
Thank you.
Thanks, Frank.
All right, Judge, next is page 16, Ramirez, Mark.
Judge, for Mr. Mukes, did you want me to file the no alcohol, no drugs?
No, because it's anytime something where they're going to be supervised, pretrial does it, so you don't have to.
Thank you.
You are Mark Ramirez. Mr. Ramirez, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir. Okay.
Thank you, Your Honor. On April 18th, 2025, in Harris County, Texas, an officer observed a motor vehicle stopped in the right lane of traffic with its hazards on. The officer approached the motor vehicle and observed the defendant to be asleep in the driver's seat. The officer parked his motor vehicle in front of the defendant's vehicle and attempted to wake the defendant up. Once the defendant was awoken, he allowed his motor vehicle to roll forward and strike the officer's vehicle. The defendant then turned the vehicle off, but failed to put it in park, leading the motor vehicle to roll backwards and strike the other officer's motor vehicle that was on scene behind the defendant's motor vehicle. Once the defendant exited the vehicle, he became uncooperative and was required to be detained by the officers. The defendant would not answer any questions and kept saying, "Oh yeah," over and over. The officer observed a strong odor of alcoholic beverage emitting from the defendant. The defendant declined to participate in standard field sobriety tests initially. Once the defendant was transferred to jail, the defendant stated that he wanted to perform the standard field sobriety tests when asked to perform them again. The defendant was read Miranda warnings and stated that he wanted to speak to the officer. The defendant then stated that he had a 12-pack of beer since he had gotten off of work. The defendant stated he did not know what time it was and what time he stopped drinking. The officer observed the defendant to have bloodshot eyes and slightly slurred speech. Standard field sobriety tests were conducted. A 6 out of 6 on the HGN, a 3 out of 8 on the walk and turn, a 2 out of 4 on the one-leg stand. The DIC was read, and the defendant consented to providing a blood sample.
Ramirez, I'm going to find that there's sufficient probable cause to go forward with the case. If you have a problem with drugs or alcohol, now is the opportunity that you're going to get to address it. If you don't, and it becomes a problem on bond, I'm going to address it for you, and I promise you're not to like the way that I do it. Do you understand?
Yes, sir.
You are not to use alcohol, illegal drugs, unprescribed controlled medication. I'm going to test you like crazy to ensure that you're not using. Any prior DWIs, and does he have a license, please?
Judge, I don't have any prior DWIs and I'm checking the license right this second.
If you do not have liability insurance and a Texas driver license, you're not allowed to drive, and that is also a condition of your bond.
Judge, we have that his license is eligible.
Okay. Do you have the ability to hire a lawyer, Mr. Ramirez? Do you work? How old are you, sir? Okay. We're going to give you time to hire a lawyer, so I will have you go to Victoria Center Reset, and then I'm going to have you take your seat in the jury box while we get your bond conditions. A, don't use. Do you understand? You're going to get called to tested. If you fail to appear, I'm going to issue a warrant for your arrest. You understand? All right?
Well, you have. This one.
All right, Judge, next is page 16, Raina. Noel, Raina.
I did.
So not much court hopping going on today. There's a lot of places that I could go. I've got my eyes on 7 other courts that are all pretty busy, but seem to be enjoying Judge Fleischer. So unless there's an objection, we're just going to keep going with Judge Fleischer. I mean, just to be able to watch the leopard man at work alone is worth it.
Good morning, Ms. Simmons.
Hello, sir.
Ma'am, you're charged with assault, bodily injury. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you.
Thank you, Your Honor. On April 17th, 2025, in Harris County, Texas, officers were dispatched to an assault call. Officers arrived and spoke with the complaining witness, who stated her and the defendant are neighbors. The complaining witness stated the altercation was only verbal until the complaining witness exited her apartment unit and observed the defendant approach her while calling her names. The complaining witness states that the defendant then struck her 3 times on the head with a closed fist. The complaining witness stated a witness was able to separate them. The complaining witness exited her apartment unit approximately 1 hour later, at which point the defendant approached her again while stating that when the defendant was in jail, she heard the CW was talking bad about her. The complaining witness stated that the defendant then struck her on the face and head with a closed fist 5 to 6 more times. The witness stated he observed the defendant pulling the complaining witness's hair, but did not witness any striking or punches thrown. The officer observed a light red mark on the complaining witness's cheek.
Any alcohol?
Take a closer look here.
Ms. Simmons, I'm going to find if there's sufficient probable cause to go forward with the case. I'm going to tell you now that I will do everything in my power to protect my community at all costs. I don't know what kind of resources you have here, but if you don't have anyone to pony up $5,000 to $10,000 if I revoke your bond, you will be stuck like Chuck in there until this case is over. Do you understand?
Yes, sir.
I don't want you to consume alcohol or illegal drugs, and I don't want you to have contact with the complaining witness in this case. I don't want you to go within 500 feet of where she lives or where she works. You understand?
We live right across the hall from each other.
Don't want you to go anywhere near her. I don't want her to be in fear of when she's trying to get home.
I understand.
Actions have consequences, and I don't want you to go anywhere near where she lives or where she works. You're also not going to possess any weapons as well.
Judge, after taking a closer look, it doesn't specify whether or not alcohol played a role in this event.
Do you have the ability to hire a lawyer, ma'am?
No, I don't. I need one.
Okay. I'll give you an application. We'll see whether you qualify. I need to know everything about you, how much money you have coming in, where from, cars, anything, money in the bank, and then we'll take a look to see whether you qualify.
All right, thank you.
Miranda's going to give an application. You will meet with Pritchard for your bond conditions, then we'll have you meet with someone shortly.
Okay, thank you.
Yes.
Your reset?
I'm going to visit the gym.
Okay. What is on the next one?
Okie dokie. Well, he's stepped away for a minute. Let's go. Let's go to Judge Meineke. Let's go there.
Your name for judge, please.
Yes, my name is Asma Al-Basiri.
And Your Honor, we're here for an adjourned probable cause conference. I've been gathering materials from Miss Al-Basri for a mitigation so that we can try to keep the case with you here in district court. She got me most of the information, if not all of it, yesterday. So I'm just asking for one more brief adjournment. I can get the letter to Ms. Rosnow by the end of the day Tuesday. And then if we could do a couple weeks, if that would be enough time.
Madam Prosecutor, is that okay with you?
Yes, no issue with the adjournment, Judge.
All right. It sounds like there has been some effort, although it would be better if we get that stuff to you earlier, Mr. Bennett. But
Yes.
I adjourned this PCC 2 week. Well, wait, I think 2 weeks is when we have a judicial conference at that time.
On May 9th, I think.
So May 16th then.
That would be fine, Judge. Thank you.
I will want to either be setting it for exam or resolving that day, okay?
Absolutely, Your Honor. Ms. Rosnow, I'll get you that letter middle of next week at the latest.
Okay, thank you.
All right, 8:30, 1 a.m. Bond is continued. Thank you.
Perfect. Thank you, Judge.
All right, Judge Fleischer's back. You know, I would have Ellie in here because I'm sure Ellie would appreciate this, but she's out sleeping in her bed outside the studio right now, so she'll have to catch it on a replay, I guess.
Talk to me real quick.
Yes, sir. Good morning. I have Francisco Mendoza. He set for bond forfeiture today.
Yeah.
He's at UT Center on involuntary committal.
Reach out to Victoria. I can't hear you, but I'm okay with it.
Okay.
Reach out to Victoria. All right. Happy Friday.
You ready for the next one, Judge?
Yes.
Quiet. Page 23, Walker.
Hey.
Come on up.
Hey, you check on those sodas.
No, not yet.
Hey, did you get your girl, man? Come on over. You're Mr. Walker.
Yes, sir.
Mr. Walker, you're charged with driving while intoxicated, second offense. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Thank you, Your Honor. On April 20th, 2025, in Harris County, Texas, law enforcement officers were dispatched to a report of erratic driving in a gray BMW sedan, nearly striking other vehicles. The law enforcement officer located the vehicle and paced the vehicle going 85 miles per hour and a 65 mile per hour.
Hey, don't talk. Don't talk. Can you start from the beginning, please?
Yes, Your Honor. On April 20th, 2025, in Harris County, Texas, a law enforcement officer was dispatched to a report of erratic driving of a gray BMW sedan, nearly striking other vehicles. The law enforcement officer located the vehicle and paced the vehicle going 85 miles per hour in a 65 miles per hour zone and saw the vehicle almost strike a delineator pole. The law enforcement officer initiated a traffic stop and made contact with the defendant. The law enforcement officer observed a strong odor of an alcoholic beverage, slurred speech, red glossy eyes, swaying, and unbalance from the defendant. The defendant admitted to having 2 beers prior to driving, or 2 alcoholic beverages unspecified prior to driving. Standard field sobriety tests were conducted, a 6 out of 6 on the HGN, a 5 out of 8 on the walk and turn, a 2 out of 4 on the one-leg stand. The law enforcement officer found an open container of an alcoholic beverage on the passenger side floorboard, cold to the touch. The defendant consented to breath and blew a .137 and a .127.
Mr. Walker, I'm going to find that there's sufficient probable cause to go forward with the case. I am now taking away your ability to drive. You are not allowed to drive. Do you understand? You will be signing an affidavit with me today, promising me you're not going to drive. I don't give a rat's behind what your excuse is. If I find that you drive, I can have a contempt hearing. You can be facing an additional 6 months in jail and a $500 fine every time you drive. Do you understand? Because it's a second offense, I'm requiring you now to get a portable device that you're going to take with you everywhere you go to prove to me that you're not consuming alcohol. If I find that you do, I will put you in jail. No more PR bonds for you. Do you understand? You're not to consume alcohol, illegal drugs, unprescribed controlled medication. I'm going to randomly test you. Does he have a license? Can you run it?
Yes, Your Honor.
We're going to reset your case to give you time to hire a lawyer. So I'm going to have you come up here, swear to us that you're not going to drive. I'm going to get you to Victoria where we will have you sign a reset. You will then get with pre-trial for your bond conditions, and after that, you'll be free to go. When you come back, please have a lawyer. Please.
Your Honor, we have the license eligible.
Bailey, you raise a good point regarding Ellie. For those of you who might be new to the channel who aren't clued in, Ellie is my quote-unquote co-host. She is our 1-year-old kitten, one of our kittens. We actually have two, but Io never shows up. Ellie does. And we have a problem with Judge Fleischer that he's constantly talking about he doesn't care if there's 50 kittens in a burning building and you have to drive there to save them, you can't drive. That's the lecture he gives when he revokes somebody's driving privileges. And I got to tell you, Bailey, you got me thinking on this. This is like cultural appropriation against all of our feline friends from a man who routinely calls for their death. I'm offended.
Every single officer in the state knows that if you're in a vehicle driving, that vehicle is supposed to have an interlock on it. If you're caught and you don't have one, they will take you to jail. As it stands now, as part of your bond conditions, I'm warning you not to drive for the time being. Do you understand? Look, it's not, I'm just, no response is required. I'm just telling you what the expectations are. And if you violate these conditions of bond, I will revoke the bond and I'm going to put you in jail.
I know, I'm trying to get a real good understanding. That's why I want to ask the question.
A lawyer. I don't want you to ask something. I don't want you to say something that hurts your case. We're going to give you time, please.
There was one that's being taken for felony open warrant on page 16.
Let's do it.
All right. What happened, Simon? Go to slide, please.
You said page 16?
Yes,
Oh,
yes.
that's right.
Bottom of 16.
Wow.
There's a one separating.
Yes.
Starting to get that. It does start from this. For now, yeah, it's gonna be.
I've granted all the ones that are. All right, good morning, Ms. Arena.
Hello, how are you today?
We took you into custody, or we have you in custody now because you are on deferred for an aggravated assault of a family member. And a motion, I'm assuming a motion, let me make sure. Yeah, it looks like a motion to revoke has been filed and you are at a bond denied status now, meaning that you're being held at no bond. So what we're going to do is we're going to do probable cause in this case here. We have to take you into custody. You will probably populate on Monday's docket for the felony court.
For what?
You're now charged with driving while intoxicated.
Now, see, here's the thing.
Oh, did I ask you to say anything?
No, sir.
Okay, please. You have the right to remain silent. Exercise that right. You
Yes,
may
sir.
say something that hurts your case unknowingly when you're trying to think that you're helping. Just don't.
Yes,
We're
sir.
going to do probable cause. Like I said, you have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you. I'm going to appoint you a lawyer after we do probable cause to you. You can speak to someone here momentarily. Okay? So let's just do this real quick and then. Okay.
Thank you, Your Honor. On April 19, 2025, in Harris County, Texas, a law enforcement officer conducted a business check of an Exxon gas station. The officer observed a motor vehicle at the gas pump without a front license plate and with the brake lights on.
Start from the beginning, please.
Yes, sir. On April 19, 2025, in Harris County, Texas, a law enforcement officer conducted a business check of an Exxon gas station. The officer observed a motor vehicle at the gas pump without a front license plate and with the brake lights on. The officer observed a male asleep behind the wheel in the driver's seat. The officer contacted the defendant and observed him to have red, glossy eyes and a strong odor of alcoholic beverage emitting from his breath and his person. The defendant initially refused to obey verbal commands to exit the vehicle. The defendant then exited the vehicle and stated that he would not allow any deputies to detain him and would not perform standard field sobriety tests. The officer took the defendant into custody. The officer notes that the ADA accepted charges under no refusal and that a specimen was not needed.
Did anyone see him drive? He's sitting at a pump, he's sleeping. I mean, the officer tried to go look at camera footage to see if they see him driving at all. Does anyone have him driving?
Judge, we do have camera footage from the Exxon recording the defendant driving into the gas station on the dim sum. Yes, Judge.
All I'm asking is, do you have something that shows him driving? Okay. Mr. Rain, I'm going to find that there's sufficient probable cause to go forward with the case. I'm ordering you as a condition of your bond not to consume alcohol, illegal drugs, unprescribed controlled medication. I'm going to randomly test you. If I find that you're using, it's not going to go well.
Yes,
You
sir.
understand? Just don't use alcohol or illegal drugs.
I completely understand.
Okay. Hold on. Does he have a valid license? Can you check, please?
Yes, Your Honor. I will check.
As long as you have a and then does he have any prior DWIs, I guess, as well?
There's no prior DWIs.
Okay. License.
And the license status should be ready for my review. Pulling up. It is. Trying to load up. It says it's eligible, Your Honor.
Great. Before you say something, let me please give you a lawyer and let me have you talk to the lawyer. And then whatever issue you may have, they can come back and talk to me. I just don't want you to say something that hurts your case in any way. I'm trying to help you, I promise.
You
Yeah,
understand?
just don't. So go ahead, put him back. We'll give him a lawyer, but don't send him down because are you ready for conditions? Okay, take your time. No rush. Okay.
On this issue.
Hey, Vic.
And off he goes again. Let's go back to Judge Meineke.
And so I will just again place on the record this morning that we have no objection to using Zoom for this proceeding.
All right. Anything on behalf of the people before we proceed to sentencing?
No, Your Honor, I'll leave it to the court's discretion.
Ms. Krauskopf.
Your Honor, I am asking for a time served sentence and to close out this case. We had adjourned this sentencing until after Ms. Bridges was sentenced in Macomb County. She was sentenced in Macomb County this week to a term of incarceration with the Department of Corrections. That term is a minimum 18-month term. She was booked into the Macomb County Jail on September 17th of 2024. I believe when she was sentenced on Tuesday in Macomb, she had 266 days credit there, something like that. So I know she's not technically entitled to jail credit on this case until the date of her arraignment here, but I did want the court to consider how long she has been incarcerated overall. Because of the situation in Macomb, I don't think that there's anything left that we can do for her here, unfortunately. I would just ask that the court give her a time served sentence. My only concern, obviously she's not going anywhere after today. My only concern with this court giving her any more county time is that sometimes even when the court orders that time run concurrent, I have had situations where someone has finished their Department of Corrections sentence and there has been some sort of insistence on MDOC's end that they need to be returned to a county jail to finish out the last 2 months or, month and a half or whatever it is. So in order to avoid that complication, to make sure that she can be paroled when MDOC deems that appropriate, I'm just asking that the court give her a time served sentence at this point.
All right, Ms. Bridges, if you could just unmute real quick. Is there anything you'd like to say before this court imposes sentence?
Oh, you can hear me?
I can hear you now, yes.
Yes, I'd just like to say I take full responsibility for my actions.
All right. Ms. Rosenau, was there any sort of restitution or anything that I need to be aware of on this one?
There was, Your Honor. I don't know that I'm not prepared with that number. 1 second. I think Ms. Bridges has been ordered to pay restitution to the amount of $200,000 in the other case. Is that correct? So it's somewhere around there. Yeah, it's much more significant than whatever this number here would be.
It looks like it looks like the property was damaged, but not okay. The cost of repair was $4,000. That's
yes.
I think the court certainly can take a look at the circumstances here, and I can I can leave a restitution order open, but recognize the likelihood of it being complied with is very low. So, I think I still have to order it, Ms. Krauskopf, but what happens as a result of it will, I don't think there'll be anything holding her up going forward, because I'll suspend all payments while she's in custody.
Okay, thank you, Your Honor.
All right. I know that, traditionally courts will not give credit until they're actually arraigned, but it always blows my mind how we have a case here where the warrant has been issued, and the warrant is out there as of April of 24. She's been in custody since September of 24.
Yes, Your Honor, September 17th of 2024.
So nobody anywhere these are the things that always took note that she would have had an open felony warrant in Oakland County. Obviously, that's not on the people, but I would have thought that somebody who had arrested her or had her in custody would have provided some additional notification. So I always feel like that seems like a failure of the system, and it shouldn't be held against someone when it comes to credit. So so you say since September 17, 2024, she's got 266 days?
Yes, Your Honor. Let me just verify my math on that, but I'm fairly certain that is what the order from Macomb said. 229 days, I'm sorry.
229. Okay. All right. It's a sentence of this court that she'll serve 229 days in jail with 229 days credit. I will give her credit for the time she was doing. And I will order $4,000 in restitution. That way you're covered, Ms. Rosenau, with making sure that the victim at least got a restitution order. But I
Yes,
will
thank you.
delay all payments for, so she's in for 18 months. She would have gotten credit for 229.
229, yeah.
Okay, so I'll delay all payments for 18 months while Miss Bridges is in MDOC. And when you come out, Miss Bridges, it's not like all of a sudden there'll be someone knocking at your door with a handout waiting for $4,000. You just got to call us and we can set up like a small payment plan. All right.
Okay,
All right. Good luck to you, ma'am.
thank you.
All right, Judge Kitty Cat is back. Let's go back to his court.
I'm going to find that there's probable cause to go forward with the case, and I'm now going to put a monitor on you so I know where you are at all times. If you get out of custody, because now I'm revoking your bond, you will go to jail. If he gets out, GPS monitor not to go within 500 feet.
He has a GPS monitor on him.
Putting him in custody. No alcohol, no drugs, no weapons, no going within 500 feet of where the complaining witness lives were. And I'm going to tell you now, because I don't know if you're going to get out, but if you do, you endanger my city again. I'm going to go ballistic on all of your bonds. Do you understand? Goes with you.
I have a,
Judge, I have no reason to doubt that,
Scott, just, there's no need. It's done.
Or the time.
We have 5, 6.
We'll check to see if she's getting if she doesn't open your yeah, just check the burn. I will see. Yeah.
It was during the day though.
Yes, sir.
What time of day was this?
I have here, 3:26 PM. Yes, sir.
You know, Bailey, listening to SCOTUS arguments is actually one of the things that's always on my list and something that I never actually seem to get to. So things are going a little bit quiet there. Let's do this. We started the day with Judge Flores, who is, oh, no, wait, somebody.
Ms. Bledsoe, originally her bond was revoked. She doesn't have a cell phone anymore or anything like that. We're back in touch. I have her mom's number. So I'm able to reach her. On her last court date, I did plan on setting it for trial. That is still the intention today.
Is she here?
She's here.
Okay. So why don't we just set it now?
Yeah, right.
All right, let's come up. Every time you take off and when we revoke your bond, all you do is you're giving money to bonding companies. You just enrich bonding companies. That's all you do. I don't know if you got a lot of free money, but if so, I guess we'll stick with the conditions that we had before, just no contact with the complaining witness, no weapons. So do you have an offer in this case now?
We do.
Okay, so we're gonna set your case for trial today. You must appear for trial date, 8:30 in the morning. Don't appear at 12, not at 1, and then we'll be set. I guess May. Let's see, today's what, 25th? May 27th, okay with you?
Yeah. Judge, that's a short week.
Oh, yeah.
June 10th or May
What
20th.
do we have on the 3rd, Ramona?
I'm sorry?
What about the 3rd?
Victoria's out that week.
June 10th. Is June 10th a holiday week too?
Yeah, we can make it a holiday week.
No. June 10th it is.
No, June 10th, Judge.
Everybody's a comedian.
Thank you, Judge.
Voting.
Okay. Thank you. Thank you.
We're gonna have recite the petition.
Hi, you ready? Yes, ma'am.
I picked up Mr. Mook's case today. I'm not sure how to pronounce that, but
That's right.
yeah, I think he left already. But I was wondering if we could rehear PC.
Okay.
Oh, he did? Oh, okay. I'm sorry.
But I hope, because I had asked him to reach out to the complaining witness just to make sure that she's okay.
Okay.
Because if she,
One issue there. So because it was resisting, it's not in our system. Contact information is not in our system. Now, when the offense report goes through, it should be. Problem is we don't have that offense report yet. I'm gonna keep checking it. I can try to run through RMS.
I mean, until I know, yeah, that's Mr. Mukes right there. So until I know, I'm gonna order no contact, because I don't know, because she was scared of him,
Uh-huh.
so.
I understand. I was wondering if I could, I'm just approaching on PC for it. Yeah, but
Oh.
to rehear PC, yeah.
Okay. Sure. Do you mind reading it again? Please.
Officers were dispatched to a disturbance call on April the 19th of 2025. Officers observed the defendant to be outside of the residence with what appeared to be an injured hand. Defendant stated he had injured his hand while punching a wall when he was in an argument with his wife. Defendant stated he was drinking, quote, Crown, and requested medical attention to the scene. Officers attempted to make contact with a female at the residence who refused to open the door. She only stated that the defendant should not be at the residence and that she was in fear of the defendant. Defendant advised that he would leave the location and return at a later time. Later on that day, the defendant contacted Precinct 7 dispatch and stated that he was going to kick the door down at the aforementioned residence. Officers returned to the location and made contact with the defendant, who stated that he was going to kick the door down as soon as officers left the location. Due to the defendant's apparent intoxication and the danger he posed to himself and others, officers attempted to place the defendant in custody for public intoxication.
Here's my problem. I didn't have a problem until that point.
Right, I understand that, Your Honor, but if the police are arresting him for public intoxication, the front door is not a public place under the statute or under case law or under the
It's outside.
definition. It doesn't
That's
matter.
right.
It doesn't matter. It doesn't fall within the definition of a public place. Public places are where multiple people go through. They're common areas. It's not a public place.
He's not in his house.
It is his residence. It's
No,
his
he's
residence.
outside.
He's outside, and I would argue.
He's
Your Honor,
outside. He's not inside the house. He's
He's
outside.
right at the front door, and so.
I mean,
Your Honor, I would argue a mailman go up to the front door, the other packer goes to the front.
I don't
door,
think under the
driver-
statute it qualifies. I mean, I have.
show me
the-
a case that
Sure,
says
I have the definition.
door is,
Right, I have the definition of a public place under
I
the
know what
Texas
the
Penal
definition of
Code.
a public place.
And it's like
Should-
apartments, hospitals, libraries, schools, office buildings, sidewalks, like driveways, the public road, not the front door. I mean, even the police, like, there is a reasonable expectation of privacy of going into the front door of the house. Like, it's not really considered a public place under the statute.
Show me case law, because I don't know. I mean,
I'll try, I can find.
I know I know the definition. I've seen the
Right,
definition,
yeah.
right? But show me something that says that a being, near the front door is private property,
the
so
front
it's
door.
not.
I mean,
right.
at the front door. I mean, that is like, I mean, people have a reasonable expectation of privacy in their home, like.
In their home,
Right,
yes.
and at the, like, even at the very, like, front of the door, I mean,
We don't know exactly where he is.
but that's what the DIM says.
Okay,
Your Honor, what I would say, he's clearly not in the house, he's at the front door. He's threatening to kick the door down after they had just gone out on a domestic related call. And she said he appeared to be intoxicated. He defended himself, told officers that he was drinking Crown. They decided that based on the facts, he was a danger to himself, and they decided to place him in custody for public intoxication.
Mr. Mukes, coming up.
I'll turn the live stream off.
Can we turn the live stream off? I hate that. Stop it. You know, I was just about to like praise her. I will say that set of public defenders that he's got for his courtroom is really, really good. But is this the one? I think she's the one that keeps asking for the live to be turned off. Correct me if I'm wrong, but I think that's the same one. And that just annoys me. Not just because I'm doing a show, but honestly, the world is different now. The expectation of privacy is not what it used to be. And I'm sorry, everybody's being recorded all the time. At this point, until we have the solar flare that knocks everything out, we all got to kind of get used to it. Just my
Yes,
opinion.
sir.
All right,
Please,
back to it.
Mr. Marlon Simmons. Mr. Marlon Simmons, Your Honor. Very quickly, Judge.
Real quick, while he's coming up, I was also going to say that I was going to keep an eye out for if she comes back later with case law after the stream and do a video on it, but she'll just ask for it to be turned off anyways.
Brandon wants to, I heard we can't. She's didn't have comments. She's not calling. She can find out.
Right. I said, you know, the messages get sent to me, so get a photo by how you get here each day.
You know what I mean? So you let her know. If mom doesn't have to be contact with her, doesn't let her know to come in and get work, you can make them bond. Yeah, I'm not, hey, let her know we're not gonna play games. I don't care.
Mr. Marlon Simmons, Your Honor. This was a DWI PTI that went south.
Why for a plea?
Was tested positive for THC and alcohol, and they just picked a charge out of Waller County for operation of a salvage vehicle on a public roadway.
Okay, so this case is 517 days old. Do you have an offer on the case?
Yes, Your Honor. This was a 12-month probation since it's been kicked out of PTI.
Okay, so you must either accept the plea bargain from the state or I'm gonna set your case for trial today. So they've offered you a 12-month probation. You talk about it with Mr. D to see if that's something that you want to do, because I don't know. Is that the only offer you have?
That's the offer I've made, yes. That's the
Okay.
offer for now.
So,
He's already spoken with me, Judge.
so you let me know what you want to do.
The plea is ready for right up there.
Yes.
Yes, sir.
Oh, I didn't realize.
Yes, sir.
Okay.
And that's straight probation, Your Honor.
I'm going to tell you now that we've repeatedly asked you, we've repeatedly ordered you not to use. So you either don't care about the bond conditions or you got a problem. And I'm going to tell you now, we put someone in residential treatment, kicking and screaming that they didn't want to go yesterday. So if you continue to test, I can modify your conditions to put you into an inpatient treatment program at a minimum of maybe 3, 6, 9 months, maybe a year and a half, depending on how well you respond to treatment. Do you understand? So, and I'm telling you now, I will test you like crazy. The first instance you use, it's not going to go well. I will issue a warrant for your arrest. We will have a hearing if they prove it to me, because I'm not letting you go until the act is clean. Do you understand me, Mr. Simmons? This system will not fail you. The agreement that you have worked out is 180 days in jail to be probated for 12 months. As part of the agreement, you will do a DWI education class, 2 victim impact panels. Has he done a TRAS yet?
They recommended supportive advocacy.
Was that the
The
way?
Mhm. Okay.
Let's do a new one.
Stop it.
Substance abuse treatment as required by the TRAS. No breath test refusal, meaning that if you're pulled over, an officer asks you to take a breath test, you must do it while you're on this probation. No drugs, alcohol, and a guardian interlock.
Judge, with respect to the guardian interlock, client has informed me that he does not have a vehicle at this particular time. So I will respect request that the court allow him to use the portable device in lieu of the guardian.
I'm okay with that, but I'm telling you now, Mr. Simmons, that you will be signing an affidavit promising you're not going to drive. I don't care what your excuse is. Holy Mother Mary comes from and asks you for a ride from church. You drive. You can be facing an additional 6 months in jail on a contempt and a $500 fine every time you drive. Do you understand?
Sure.
Do not drive. Is it because he doesn't have a license?
He does not have a vehicle, he informed me, Judge.
Do you have a driver's license?
Sir.
Okay. We are sending notice to DPS so that every officer in the state knows if you are in a car driving, you are to have a guardian interlock, a breath test device. If you don't, you're caught driving a car. They're going to put you in jail. Don't be sneaky. Do you understand? You're giving up the right to a trial, right to compel witnesses to testify on your behalf, to confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization under federal law. You give up the right to appeal once you accept this agreement. You can never change this. The other thing, Mr. Simmons, is this now will reflect as a conviction on your record. You ever get pulled over in the future, be it 20 years from here, 30 years, you even have the faintest smell of alcohol or dope, they're going to see this DWI. It's probably not going to go well for you. Do you understand? How do you plead to the offense of driving while intoxicated? Guilty and I'm guilty. I'm going to find you guilty. I'm going to send you to this agreement. Good luck to you, sir.
Thank you, Your Honor.
Thank you, Mr. Dean.
So, Ian, you said a little bit back, I don't know if she wants it turned off. That's a fair request. Somewhat disagree. Here's my take on it. The court is a public place. We've established that in the United States. Because of COVID, that public space moved online, and it's pretty much stayed there ever since. So I feel like the public should have access to it. Beyond that, even, I love Judge Fleischer, and obviously you guys too. That's why we watch him so much. But one of the things that I don't like about him is he can be very wishy-washy, and he seems to collapse under pressure. The whole reason that he got off of YouTube was because he had a few lawyers who were complaining about the live stream. So he just caved under that. I'm not a cave kind of guy myself. I believe in standing your ground and standing for what you believe in. And he was so adamant about how things needed to be public and people could learn from it and all of that. And then he pulled it back. I don't know. It's just it's a sour point with me. But let's go back. Bailey, I'm not sure if she's protecting her client or protecting herself. My take is she doesn't want to be on.
Was there restitution that was owed in this case?
No, Your Honor, it looks like, I'm just checking now, it was a single vehicle accident.
Okay. What do you think?
I'll look at the pre-rec, Judge. I think they expressed interest in giving me a deferred or getting a deferred.
Deferred?
And I'll explain why, Your Honor. Time served was offered, and that would be the most convenient route. He doesn't have to worry about anything. I gave him that option. He still is interested in trying to get his record sealed for employment reasons. And so
we literally had a problem with Mr. Bada the entire time he's been on bond for this case. So to think that something would actually change just because he's on a magical deferred, which was before, this was a way for him to get it dismissed, and he couldn't even do this. Now, are we actually going to hope and pray that he's going to make it deferred? As if.
I think one thing is,
I don't think so.
With being on the court's deferred, there's more teeth to it. Because once he enters into that, now he's exposed himself to incarceration if he doesn't succeed.
I would just as well move on, really. I mean, he's going to pay a bunch of money to get on this deferred, and then he's going to come back and say, oh, I don't have money to do this. I can't do this class. I can't do that class. And then I'm out, and wherever I'm in, whatever state I'm in, just really, let's be done with it. I mean, you can lie to us, but you can't lie to yourself. And really, if you couldn't even make this, you couldn't even make it while you're on bond. We literally had bond violation after patient. No.
One more matter for consideration. He did complete, if I'm not mistaken, all of the classes. He did do some level of completion on the PTI. It wasn't as if he completely disregarded everything. I think
that just totally went out. We can end it now, or I can. Well, hold on. Let's see. Did we get it? Did he come back?
You're pro bono. It just.
Never mind. We're back now. Glitch on their end.
Yes, Ron.
Please.
We'll try to work it out. Thank you, Ron.
Okay. Hi, Joe.
Morning, Judge. Can I Brooks?
So wait, it's your birthday?
It was yesterday, Judge.
Happy birthday, Joe. I didn't even know.
All right, you can give me a present this morning.
20, 25, 26?
A couple of times over, Judge. Times over. Judge, we're here on Irving Camano. I can give you the case number. This is the one that he was going to turn himself in for the weekends. We kind of went back and forth on the numbers. You were saying, well, if he does 6 days straight, blah, blah, blah. What happened is at the very end, I said, well, can we do 3 weekends? So set the sentence at 9 days. And I think it was set at 10. So we just need to modify it to make sure 10 straight from the end.
No, I didn't deny, so he could do the 3 weekends.
So could just do 3 weekends. Okay. And he's here ready to turn himself in. So, okay, great. All right. Thank you, Judge. Okay. Thank you, Ron.
Thank you.
Okay, Mike, regarding your question about using these live streams. So ultimately, it's a request of the court. They would have a hard time enforcing it. For this reason, we have here in the United States a fair use doctrine, which means that you have access to these feeds. Now, you also have to do it right. Technically, under the fair use doctrine, you have to be transformational with the material. So in this case, with the live stream where we're adding commentary, we're adding to the visual presentation, we're having interaction, that makes it transformational, therefore legal. With the regular videos that we do where we add visually, we add to the commentary, stuff like that, again, that makes it legal. If I were to just take his feed, post it with like nothing done to it, that's not technically fair use, so it would be a problem at that point. But my personal take on this is that fair use is a federal doctrine, and again, here in the United States, federal law trumps state law, so the judge can make a request, but ultimately it's not overly enforceable. There are actually a few judges that have actually put standing orders in where you would be found in contempt if you used their feed. But honestly, I don't see how that would stand or be enforceable either. As a courtesy to those judges, the ones who actually put in a written order, I don't use those feeds as a courtesy to them if they have the actual written order, but ultimately I could, and I believe if somebody tried to challenge me on it, I'd be victorious. But that's just my take, but I don't honestly need to get into a pissing match with a judge either. So there's enough judges out there for me to do that. Linkman are actually 4 weighted factors. Theoretically, you don't need to be transformational. Theoretically, yeah. But if you want to be very clear about it, I think it helps to be transformational. And quite honestly, it makes for better material to boot. All right, so vote of the crowd real quick. I'm willing to go a little while longer, or technically it's the top of the hour, and I sometimes quit at this point. Judge did walk away. Here's what we can do. I have a judge that we've never seen before that we could go take a look at. Or we can end it today. Put a 1 in the chat if you want me to keep going. Put a 2 if you want to just call it a day. Let me know. I'll give you 1 minute. Go. Well, my mother wants me to keep going, so I guess that means I better keep going. All right, so let's do this. We're going to go to Burnett County, Wisconsin, and this is Judge, I just forgot her name. Mogan? Hold on. Yeah, Mogan, Judge Mogan. We've not featured her on the channel before, so let's give her a look, and you guys can let me know what you think. We started the day with a judge that we haven't seen before. That was Judge Tony Flores in Lansing. So let's bookend it and finish the day with a different judge.
Which we'll hear. The second is an initial appearance. You do qualify for a public defender, but they have not yet had an ability to find one or locate one for you. So you're going to have a couple different options here. You can either say, you know what, Judge, I want to wait to see, give them a little bit more time to see if they can appoint me an attorney before we have the initial appearance. Or you can say, you know what, Judge, I'll go over and have the initial appearance with you. That's where I go over the charges that have been charged, the maximum possible penalties, and we enter a not guilty plea on your behalf, and then we set it for another hearing, which would be that preliminary hearing. Having a preliminary hearing scheduled may spur the public defender's office to find an attorney a little bit faster, but it may not. They are a little bit busy right now, and they're attempting to locate attorneys. So you would have those two options with regards to your initial appearance. Again, I will hear your bond modification request, but do you know what you would like to do with that initial appearance? Do you want to have it today on your own, or would you like to wait a little bit more time?
I'll wait.
Okay. We will go on the record in the matter 25 CF53, State of Wisconsin versus Laura Chamberlain. The state appears through District Attorney Kevin Schmidt in person. Ms. Chamberlain appears by video conferencing in custody in Burnett County Jail. We're set here today in this matter for 2 reasons. One, Ms. Chamberlain did request to have a bond modification hearing. The court will grant her the ability to argue for a bond modification. And she's also set for an initial appearance today. Off the record, the court did go over what an initial appearance is with Ms. Chamberlain and went over the fact that she does qualify for SPD services, but the report indicates that as of today's date and time, they have not yet been able to locate an attorney to handle her case. The court gave her 2 options, one to continue with the initial appearance herself here today and enter a not guilty plea and set the matter for preliminary hearing in hopes that the SPD would be able to find an attorney and be able to appoint one for that next hearing, or to have it be adjourned to another date and time to give the attorney or to give the office more time to locate an attorney to take that appointment. Off the record, Ms. Chamberlain, you did indicate to me that you will be arguing for your bond modification request here today yourself, and that you wish to adjourn the initial appearance to another date and time in the future to allow the SPD to look for and to have the ability to appoint an attorney to your case. Is that all accurate and true?
Yes.
Okay. So what I'm going to do first is I'm going to schedule this for an adjourned initial appearance date. I can do May 5th.
Okay.
At 2 o'clock, May 5th at 2 o'clock. We'll schedule you then, May 5th at 2 o'clock for your initial appearance date. Hopefully that'll give enough time for the SPD to find and locate an attorney to get one appointed to your case. Now, with regards to your bond modification request, I do have your written letter in front of me. However, I'm going to ask you to argue to me on the record what it is that you're seeking and why.
I'd like a bond modification so that I can get a place to live and a job, earn money so that I can pay bills that I've incurred and that I will incur. I feel like the time that I've spent here has allowed me to really reflect on what's happened, and I want to move forward with my life. I want to be the best person I can be and just move forward. So I'd like to be able to do that outside. I just don't feel like I can do anything in here.
So your bond is currently set at $50,000 cash due to the severity and the seriousness of these allegations and the charges. Is there an amount that you are asking the court to consider for a bond modification?
I don't know. I mean, $2,500 signature bond?
You're asking for a signature bond?
Mm-hmm.
All right. Mr. Schmidt?
Judge, I think this needs to remain a high cash bond case. To Ms. Chamberlain's benefit, she does not have a criminal history. This is an extremely serious and, most importantly, an offense that she's accused of that's of high public danger. What was found in her residence that she was evicted from was a large amount of drugs and paraphernalia, and this lab where they're creating the substance called DMT. It was in one of the later middle stages of production, and the substance at that stage is very dangerous. When we talk about acid versus basic, something is very acidic if it's very low pH, something's very basic if it's high pH. Both are extremely dangerous at the high and low end. This was an extremely basic substance in its current form, meaning it was very dangerous. That's why we had DCI have to go in there with like PPE gear to remove it and destroy it. Additionally, strewn in this residence was also numerous items of guns and ammunition. When we find guns and ammunition in proximity with a lab, that shows a high amount of danger to the public. Because it shows an intent to protect the lab, whether it's from, people who'd want to stop that operation, whether that's law enforcement or other dangerous people who are also involved in the drug trade. The evidence here is pretty strong. Ms. Chamberlain was actually arrested driving by the residence just surreptitiously when they were about to execute the warrant. They found more drugs on her person. I just watched the body cam a few minutes ago. One of the very first things she said to the law enforcement before they even brought up what they were expecting to find in there was, please don't arrest me. I think she shows guilty knowledge of what happened, and we need the high cash to ensure protection of the public. Thank you.
All right, Ms. Chamberlain, it appeared that you wanted to make a statement or say something in response to the district attorney's argument.
No, I just thought we were waiting on an initial appearance.
This is not an initial appearance. This is your bond modification request, and he's indicating with these facts, it needs to stay where it is. Based upon the arguments and knowing that you have been alleged to have committed very serious crimes, and the highest here is a Class C felony, that means that a maximum possible penalty of 40 years of incarceration, $100,000 fine up to that for manufacturing and delivering designer drugs. Again, it's an allegation, but there are serious allegations, and there are at least facts that rise to a level to want to ensure the safety of the public, because this is a high public risk and high public danger danger type of matter and case. Based on that, the court is going to deny your modification request. It doesn't mean that this is the last time you can request a modification. Once you get an attorney, you can go over the facts and information with that person, and you can again request to have your bond modified. But at this time, based upon the facts that the court has in front of it, I'm denying your request. We are adjourned. Are you Mr. Chaffee?
Mr. Chafee, yes.
Chafee? Mr. Chafee, you, like Ms. Chamberlain, you do not have an attorney. They have tried to locate an attorney for you, but one has not yet been located for you, I believe, or you have not applied for a public defender yet. I have not gotten that report, so I don't know if you've applied or if they just haven't found one for you yet.
I have applied. They said they were sending me paperwork this week.
Okay, and so you, like Ms. Chamberlain, have the option to either wait on your initial appearance or to have it set in a date in the future to give an opportunity for the SPD to find and locate an attorney for you. Would you like to proceed on your own here today and then set the next hearing date, or would you like to wait until an attorney can be appointed to you?
I guess I hadn't really thought about it much. I guess I'll wait.
We will go on the record in the matter 25 CF 54, State of Wisconsin versus Zachary Chafee. The state appears through District Attorney Kevin Schmidt in person. Mr. Chafee appears by video conferencing in custody in Burnett County Jail. This is a return on warrant and initial appearance. The warrant is now quashed. We do need to set bond in this matter. Off the record, the court did inquire as to whether or not Mr. Chafee has applied for the SPD, and if he qualifies, he indicated he does. The court also inquired as to whether Mr. Chafee would like to continue with his initial appearance here today and represent himself on this matter, or adjourn the matter to a date in the future to have more time for the SPD to find and appoint an attorney for his case. He requested that the court adjourn the matter to another date and time to allow the SPD more time to locate an attorney. Is that all correct and true, Mr. Chafee?
Yes, ma'am.
The court will adjourn your initial appearance to May 7th at 2 o'clock, May 7th at 2 o'clock. Mr. Schmidt, we are here on bond as well. Argument for bond. He is a co-defendant with Ms. Chamberlain. She is currently set at $50,000 cash with other certain conditions. What is your argument?
I would ask for the same bond and same conditions because it's really the same offense. There were two additional charges on Ms. Chamberlain's criminal complaint that had to do with the drug she was actually and physically in possession of when she drove the car up to the residence. What's more concerning about Chafee, even though he has less charges, is because he's got a more substantial criminal history and he appears to have a much stronger connection to other states than Wisconsin. What I mean by that is he has no prior convictions in Wisconsin. In Minnesota, he has several convictions, a 2020 drunk driving offense, a 2018 possession of ammo or firearm by a person convicted of a drug offense and driving through a barricade. In 2016, he was convicted of possessing 25 grams of methamphetamine. He got a stay of adjudication. It was dismissed at the end. 2013, a felony second-degree assault with a dangerous weapon. 2013, violating a domestic abuse order. 2013, interfering with a peace officer. In North Dakota, he has a conviction for DC in 2012. In Iowa, he has a conviction for felon in possession of firearm, possession of meth, and drunk driving. He should be on probation for that now, I believe, based off of the NCIC. I think he was only sentenced on that in November of last year. So given that he has those prior convictions in multiple states, the state's concerned with the connections to other states, he has greater ability to flee. The past convictions related to possessing a firearm, even though he's a felon, are concerning because there are numerous firearms in this building. Thank you.
Mr. Chafee, do you care to make an argument on your behalf as to whether or not the court should follow the argument of the state? Do you wish to make your own argument as to what you believe the court should follow?
Yes. I don't believe that he should even brought up that I had a stay of adjudication that was adjudicated.
been adjudicated of that. That should not have gone on the record at all. As far as I'm concerned, that charge is null and void.
Was it dismissed?
It was.
Or was it like our DJOCs?
I was.
According-
And it was dismissed.
According to MCRO, he pled guilty, he was convicted of it, he went on probation, and at the end, they dismissed it after he completed probation.
It was a
Yes,
deferred
I
judgment
was
of conviction,
dismissed.
Mr. Chafee. It's a deferred judgment of conviction. That means it still can be viewed in light of your criminal history, even though you are not convicted of that felony any longer. It is still able to be viewed in your criminal history. So with respect to other arguments, what are you arguing the court follow for or do for a bond?
And I'm hoping for a lower bond. I just had a major loss of family. My little brother and his wife passed away in a house fire. I'm still grieving the loss of my close family. I just would hope to be on the outside with my family grieving at this time.
When did that happen?
March.
All right. Based upon the arguments here today and the fact that in looking at the seriousness of this offense and these offenses, there's a Class C felony and a Class I felony. A Class C has a maximum possible penalty of 40 years of incarceration, up to $100,000 in fines and fines. A Class I is 3.5 years of incarceration, $10,000 possible in fines. These are serious. They are a public safety risk and they are a danger to the public. You have an extensive criminal history, whereas co-defendant doesn't have any criminal history. You do have connections and ties to multiple out-of-state areas. Therefore, based upon that, the court is going to order $65,000 cash. You may not use or possess alcohol, illegal drugs, paraphernalia, or controlled substances. If you have medications, you must have a valid prescription, legal in Wisconsin. You must maintain absolute sobriety. You're subject to random testing of blood, breath, and urine by law enforcement or by corrections officers upon arrest or reasonable suspicion. I'm also going to add there that you know you're a felon. However, no use or possession of any firearms at any time or any weapons at any time. We are going to again set your adjourned initial appearance for May 7th at 2 o'clock. I would strongly encourage you contact the public defender's office again next week to try and nudge them along to see if they found an attorney to represent you. Because again, this is a very serious matter and we will hear you on May 7th. At which time you can request to have a bond modification hearing again, but it must be made prior to that date and time. The request has to be made prior to the date and time of the May 7th hearing. Thank you. We are adjourned.
Okay, everybody, do we like this judge? Would you like to stick with her for a few more minutes? Let me know in the chat here real quick. I will say they win the production award. Video is very good. The audio is crisp. We don't see this kind of stuff out of a courtroom. This is where all that big money that they have in the county of only 16,000 people goes to, I guess. It's pretty impressive. But let me know real quick. Do you want to keep going for a few more minutes?
Bond was set a while ago when you were arrested. You can request, I can hear you on bond if you wish to be heard on bond here today. No, I can't because I need victims' rights compliance. I can set you for a bond modification hearing as long as we're in victims' rights compliance, but it has to be 5 business days from today's date if you wish to be heard on bond. And I can do that if you request that here today. With regards to your initial appearance, you can either have the initial appearance here today and do it by yourself and enter not guilty pleas and set the matter for another date and time in the future. Or you can say, you know what, Judge, I want to wait to give SPD an opportunity to locate an attorney and appoint one to me before I proceed with the initial appearance. Do you wish to proceed here today by yourself with the initial appearance, or do you wish to wait until you have SPD appointment?
Yes, I'd like to today.
No, wait, for time limit. Oh. Did he have an initial appearance?
Yeah.
Oh, you had an initial appearance. Okay, this was just set for a status to see if you had an attorney. That's right, because we do need to set your preliminary hearing. Okay, so we'll go on the record in the matter 25 CF 43, State of Wisconsin versus Kenneth Achterling. The state appears through District Attorney Kevin Schmidt in person. We have Mr. Achterling, who's appearing by video conferencing in custody in Burnett County Jail. We're set here today in this matter for a status conference. Mr. Achterling, the Public Defender's Office has not yet been able to locate an attorney to take the appointment of your case. So that means you can either proceed and we can set the next hearing for you to argue yourself. That is the preliminary hearing, whereas the state would need to prove that a felony was probably committed and probably committed by you in Burnett County. Or you can proceed and wait until the SPD has found and located an attorney for you. I need to set either that date and time along with a bond modification request if you wish to argue bond modification, or I can just set a bond modification hearing and wait to see if an attorney has been appointed to you by that date and time, and then set the preliminary hearing date after we've heard your bond modification. Because I'm going to guess you wish to be heard on bond, is that correct?
Yes, absolutely, Your Honor.
All right, I can't hear your bond here today because I need 5 business days to give victims rights compliance. That means victims need to be notified that there is a potential of a bond modification. So I can set that here at the next available date and time. I can do that at 11:45. No, how about? How about 10:15 on May 1st? We'll schedule it for 10:15 on May 1st. And I can do a status for that date and time too, unless you wish to set that preliminary hearing. But that hearing is, again, that hearing where the state would have to prove the burden of probably committed by you in Burnett County. Mr. Schmidt?
The officer I'd need for the prelim on this won't be available on that date. Could we do 1 week further out?
Yeah, so I can't set the preliminary hearing yet anyway. So hopefully the SPD would be able to find an attorney to be appointed to you for your bond modification request. So I will schedule a bond modification hearing for May 1st at 10:15. May 1st at 10:15. Mr. Achterling, this is simply a housekeeping matter. I'm not sure if you have written a letter to the court requesting a bond modification. If you have not, because I don't have one in the file, if you have not, can you please do so that I can get that in the file? That's just the paperwork that I need to make sure that I can have that hearing and that the victims actually do get the notice of what you're requesting. All you have to do is write a letter, give it to the jail captain or lieutenant or one of the COs, and they'll just make sure it gets to the court, okay?
All right, Your Honor.
All right, so we'll see you on May 1st at 10:15 for a status, at which time we will, hopefully you'll have an attorney and we can set the matter for a prelim at that date and time, okay?
All right, sounds good. Thank you, Your Honor.
All right, thank you. We are adjourned. Miss Achterling, is that you?
Yes. Yes, Your Honor.
Thank you. We will go on the record in the matter 25 CF 42, State of Wisconsin versus Stephanie Achterling. The state appears through District Attorney Kevin Schmidt in person. We have Ms. Achterling appearing by video conferencing in custody in Burnett County Jail. We have her counsel, Charlene Perrin, also by video. We're set today in this matter for a status conference. We have a couple things that we could do here today. We could set the matter. We need to set it for a bond modification request. I did receive a bond modification motion filed by Ms. Perrin either this morning or yesterday afternoon. I need victims' rights compliance, so I can set it at that May 1st at 10:15 date, if that works with you, Ms. Perrin, and video conferencing is acceptable.
Okay, yes, that does work.
All right, May 1st at 10:15 for a bond modification hearing. We also need to set a preliminary hearing. We can either do it now or we can wait on May 1st, Ms. Perrin, to see if at that time Mr. Achterling has an attorney, because quite honestly, for efficiency purposes, I'd like to do the prelim, if it's going to be a full prelim, together with the co-defendants.
So she is prepared to do a waiver of the preliminary hearing. And
all
also
right, we can do that right here today if she wishes.
Yeah.
Okay, so Ms. Achterling, did your attorney go over with you what it is to have a preliminary hearing?
Yes.
Where the state has the burden to prove a felony was probably committed by you in Burnett County. Do you understand that burden?
Yes.
You understand that by waiving your right to a preliminary hearing, it means that you are agreeing that at least the state can meet that burden. Do you understand that?
Yes, Your Honor.
Do you understand at a preliminary hearing, your attorney would have the ability to cross-examine the state's witnesses, to call witnesses for you to testify. You would be able to testify on your own behalf if you wished, but you don't have to. Your attorney would be able to produce evidence on your behalf or possibly discover things about the case, which could include defenses. Do you understand that for this hearing and this hearing only, you would be giving up those rights?
Yes, Your Honor.
Do you understand that if the state does not meet its burden as to the felonies, I could reduce them to misdemeanors or dismiss them altogether, but you're giving up those rights today?
Yes, Your Honor.
You understand that as a result of waiving your right to a preliminary hearing, this matter will be bound over to future proceedings, which could include a trial?
Yes, Your Honor.
Do you understand that once you give up the right, it is forever and you cannot get it back?
Yes, Your Honor.
Has anyone made any threats or any promises to you for you to waive your right to a preliminary hearing?
No, Your Honor.
You're doing so freely and intelligently. That means you're telling the court you fully understand what you're doing here today?
Yes. Yes, Your Honor.
And voluntarily?
Yes.
I will find that you are competent, you're freely, intelligently, and voluntarily waiving your right to a preliminary hearing. I will find probable cause and bind the matter over. Information, Mr. Schmidt?
Yes, I've filed the information now. It mirrors the counts in the criminal complaint associated with Stephanie Achterling.
Ms. Perrin, would you like to proceed with the arraignment here today or set it for that May 1st at 10:15 date?
We would like to proceed today with the arraignment.
She understands the charges and the maximum penalties?
Yes, she does. She would like to enter not guilty pleas for today, waive her speedy trial rights.
All right, not guilty pleas will be entered on your behalf. You are entitled to a jury trial. You would be entitled to a speedy trial should you request one. We will see you on May 1st at 10:15 for your bond modification hearing, May 1st at 10:15, okay?
Thank you, Your Honor.
Thank you. We
Thank
are
you.
adjourned.
All right, she's interesting. We might check in on her from time to time. We'll go ahead and call it a day there. Before we go, though, a couple of things. First, thanks to all of you who continually tune in, who continually watch, who have been supportive pretty much since the beginning of this live show. Some of you even before the live show. In the case of Mom, since the day I was born, and even before that. So thanks, everybody. It's appreciated. I'm continue to just be wowed by where we're at after just short of 7 months here. I know I say it a lot, but I say it a lot because it's meaningful to me. This is one of the most fun things I've ever done, and I appreciate it. Also, if you are not yet a channel member and you feel that we've done enough to earn your membership, we'd encourage you to join. It's $2.99 a month. It's not about the money for me, though, to be honest. I'm never going to get rich off of that, but that money does go right back into the channel, not into my pocket. But what really happens there is I'm really trying to build a tight community there where we can all interact and have fun. You get access to a lot of things, extra videos, a 20% discount at the Courtroom Files store, where if you're interested in merch, the membership pays for itself just in the discount. As of yesterday, members have a private email address to reach me on where we can discuss anything that you want. So there's a lot of good things going on there, and if you feel we've done enough to earn that, we'd surely appreciate it. All that having been said, everybody have a great weekend. Enjoy yourselves. Do something fun. We'll be back Monday, 10 a.m. Eastern, 7 a.m. Pacific. Again, I appreciate all of you. Take care, and God bless.